The rule here is without notice being issued, you have to be served copy.
No, sir, I mean caveat. I have filed a caveat.
Oh, where is that in one?
Sir, item number 22, I mean caveat.
No, item number 1, you are not on caveat.
Yes, item number 1, I have filed caveat for respondent 1. He is for respondent 5.
And I have served the copy. Caveat is not reflected here.
My name has not been reflected.
Sir, our name is also not reflected in 22, sir.
So let's see anyway.
Yes.
Tell me what the matter is about.
My lord, the matter is that the appellant is the branch manager of a central cooperative bank, and the respondent number 1, who was the petitioner before the honorable single judge, is a member of a trust which is a public trust. Now he has filed a writ application for withdrawal of money. His prayer in that writ application, I have quoted in page 15 of my memorandum of appeal. The two pair for quashing of the letter on 18/7/2021. This is the letter that is. This is about the letter where I have disclosed that I cannot disburse the money unless you obtain a declaration from the competent civil court having jurisdiction. Because there are a lot of civil disputes and questions are there. Then the second pair, that the issue appropriate writ order directing this bank to allowing Bansidhar Pradhan, the person who has filed the writ petition on behalf of the trust, to withdraw the amount kept as fixed deposit on behalf of the trust. This was the prayer. Then, my lord, I filed the counter and I contested it. In the impugned judgment, the honorable single judge has not hold that the competency of that particular person. The amount is a very high amount. It is kept in the name of the trust. I have challenged the authority of that particular person. The honorable single judge has not decided his competency, but directed that you hand over the indemnity bond so that he will be enabling that person to get the duplicate copy. And when my specific affidavit before the honorable single judge that the originals are available in the trust office. When the originals are available in the trust office and I filed an affidavit, in that case, whether I can be directed to some issue the duplicate to someone else who is not competent to operate the bank account. This is, my lord, I'm pointing out that relevant provision, relevant portion of that impugned order. Two reasons have been cited by honorable single judge. The first, that there was a civil dispute. His lordship has been pleased to quote that the operative portion of that judgment passed in the second appeal at running page 68, my lord. In that civil dispute, the removal of this person was under challenge, and that removal was declared as illegal. By declaring that removal as illegal does not mean that he has the sole authority to operate the bank account, if the bylaw of the trust does not permit. Now, my lord, the second reason, I have filed an affidavit saying that the original is available in the trust office. Perhaps that person who has filed the writ application doesn't have access, or he is not allowed, or some civil disputes are going on. So far as the other item is concerned, that is by some public. But that doesn't mean that I will allow him to obtain the duplicate when the original is in existence. Now, my lord, but I could not, I may be pardoned, on that particular day, I could not disclose the date on which I visited the office of the trust and obtained the copy. Even I submitted the Xerox copy of that FD receipt which I had collected from the trust office before the honorable single judge, but I could not submit the date. So, because this reason, the bank has been directed to issue the duplicate.
In 22 is appearing.
I saw the copy of the caveat.
It appears, okay, in item 1, put down item 1 and 22 together. You say both these writ appeals are directed against the same impugned. There are two orders, right?
No, one order.
Two orders, one modified order. Annexure 8 is the modified order.
You are only challenging the modified order.
No, both the orders.
Challenging the order is stated 17 October 2022, passed by the learned single judge in writ petition civil 24149 of 2021, and the subsequent order dated 10th November 2022 in IA number 14930 of 2022 in the said disposed of writ petition paragraph. In both these appeals, there are caveators. represented by learned counsel, on whom copies of the writ appeal are required to be served. Must this be done within the next week. List on July.
May I?
25th July.
I mean, Madam, IA might not kindly be considered because contempt is. It
All
is
right,
in-
status quo be maintained till then.
Yes,
All
my
right.
lord, obliged.
All right.
In contempt, notice was issued. They have yet to appeal. So, nothing is there in.
We don't know, sir.
No, it is in the item 12 today.
I am conducting that case,
Your
that's
my
why
lord
I am
has been,
addressing the lord.
my lord has passed the order of status quo. Status has been that is
Doesn't harm anyone.
Now, what will happen? They are not even giving me that format of indemnity bond. But your lordship. this was-
25th July, sir. 25th July.
As your lordship.
All right.
Item number 2.
Your lordship has directed SC to indicate our names.
Yes, yes. The names of the counsel, the cavitators be disclosed in the cost list. All right.
May I please, my lords?
Yes, please.
But the question of law, my lords, in this case, is framed at page 9, my lords.
Yes.
Though several questions are framed, my lords, I am pressing question number A, my lords, and question number C and F. Others need not be, my lords.
All right.
That's
Suppression of sales, the same.
Shortage on the ground of shortage. And your lordships have decided Radha case of some fully covered by that judgment, saying that in case of shortage, unless there is evidence of sale,
Can't be on high
per se you
estimation.
cannot proceed. Yes. And secondly, he says that there is admission. That he also strives maintenance of case, high finance case, saying that admission itself cannot be ground because whether or not a person is liable to pay tax, that will decide in terms of the provision of statute, not by admission of dealer. And
So we'll frame the question.
Your
Then.
lordship,
All right.
two judgments have given to us.
your lordship, here,
And the first appeal authority has decided by a regional order, he has reduced the demand. Now the tribunal, online tribunal by a very precise order has restored the assessment.
your lordship, so far as the suppression of the sale is concerned, all these are factual and all the details have been given. Your lordship, without recording my concession, your lordship can dispose of the matter. What happened here, your lordship, suppression has been found out, it has been admitted, and everything has been narrated, your lordship, as per the report. Basing on the report, the assessment has been completed. Your lordship, the first he has announced, the assessing officer has announced it to 8 times, your lordship, the suppression. The first appellate authority has reduced to 3 times. So, your lordship, the tribunal has stated, learning tribunal has stated that the first appellate authority, without recording it in reason, has reduced it to 3%. So, what my respectful submission, your lordship?
Go back to assessing authority.
No, your lordship, that 3 times may be confirmed. With a subject to acceptance of my learning senior, that should be the genuine reasonable order, because the tribunal, what happened? The tribunal.
If he disputes suppression itself, why would he agree to
Your
three
lordship,
times?
no, then your lordship can admit, I'll
I don't think he's admitting to suppression.
I'll tell you, only for disposal, only for sake of disposal.
What do you say?
It's a rigid order, Milos. Tribunal says not reasoned. If your lordship will look at paragraph 6, Milos, because I have.
No. So he says we can confirm the
First appeal.
first appellate
appellate
order.
order.
Ah.
So therefore, that will lead to confirming up to 3 times suppression
Ah.
instead of 8 times.
Correct.
Your lordship can do that.
All right.
Only for sake of disposal, your lordship, unnecessarily dealing your lordship by conscience. So,
right.
without recording my conscience.
All right. Admit the following question is framed for consideration: whether the tribunal was justified in interfering with the order of the first appellate authority, which had enhanced the. It limited the enhancement of the assessed demand to thrice the original demand. Question mark. Paragraph. This is an appeal by the SSC against an order dated 18th August 2015, passed by the Odisha Sales Tax Tribunal, Cuttack bracket Tribunal, in essay numbers 20 and 21 oblique 2011-12. Full stop. In turn, the said appeals were filed, one by the state, bracket SA number 20, bracket, and the other by the SSC, bracket SA number 21, bracket, against the order passed by the Joint Commission of Sales Tax, Baleshwar Range, bracket JCST, in appeal case number AA-12 BD 2007-08, whereby the demand raised by the assessing authority, bracket AAA, Bhadrak Circle, for the year 2004-05 under section 12, bracket 4 of the Odisha Sales Tax Act 1947, bracket OST Act, was reduced from 10% the original demand of 10 times of the original demand to 3 times of the original demand. Paragraph. By the impugned order, the tribunal has interfered with the order of the JCST reversed the order of the JCST and confirmed the order of the AA. Full stop. Paragraph. This court has heard the submissions of Mr. Jagavant Sakula and Senior Counsel for the Appellant SSC and Mr. Sunil Mishra Leonard, Standing Counsel for the Department. Paragraph. The SSC is engaged in the process of converting paddy into rice, broken rice, bran, etc., and is registered under the OST Act. Stop. For the assessment year 2004-05, the AA issued a notice to the SSC under section 12, bracket 4 of the OST Act and examined the books of account. Full stop. The SSC was also confronted with the fraud case report submitted by the Sales Tax Officer Investigation Unit, Baleshwar, consequent upon a surprise visit to the rice mill. Full stop. The allegation was that the STO bracket enforcement had reported 241.11 quintal of shortage of paddy, and worked out the suppression on that basis to be rupees 164,950. Full stop.
Annexure 2 is my explanation.
After considering the explanation offered by the SSC, which the AA did not accept, it was concluded that there was a sales suppression of 757.10 quintal of broken rice and 2.99 quintal of bran. And therefore, the total sales suppression was worked out as rupees 470,810. So on this basis, the gross turnover bracket GTO was enhanced by rupees 37,66,480. That is 8 times. And a demand was raised accordingly in the sum of rupees 151,348. Paragraph. The JCST limited the enhancement in appeal. In appeal, the JCST limited the enhancement to 3 times of the suppression detected and worked out the tax accordingly. The demand therefore got reduced from rupees 151,348 to rupees 56,873. Paragraph. You have a case law. We have our
Right.
decisions are there.
Paragraphs 10 and 11. Radhakrishna Rice.
Right. JCST has found the enhancement of the GTO by 8 times to be excessive. Full stop. This court, in its judgment dated 20th June 2022 in STREV 109 of 2008, bracket Messrs. Radha Keshav Rice Mill Private Limited, State of Orissa, bracket, considered the earlier judgments in Mahabir Rice Mill versus State of Orissa 1983 54 STC 218 and Lakshminaram Savalram versus State of Orissa, bracket, decision dated 20th July 1971 in OJC number 286 of 1968, bracket, and concluded that mere stock deficiency by itself would not be sufficient justification for enhancement of the GTO unless it was shown that the suppressed stock was in fact sold by the SSC. Full stop. Even assuming that the department had brought on record material to show stock suppression, as pointed out by the JCST, it did not justify enhancement of the GTO by 8 times. Full stop. That certainly was disproportionate and therefore rightly interfered with by the JCST by reducing the enhancement on the basis of 3 times the GTO. Paragraph. The court finds that the tribunal has not really set out the reasons why it was required to interfere with the well-reasoned order of the JCST. Paragraph. For the aforementioned reasons, the question framed in the present appeal is answered in the negative, that is in favor of the SSC and against the department. Stop. Accordingly, the impugned order of the tribunal is hereby set aside. Thereby, the order of the JCST is restored to file. The appeal is disposed of. Right.
Item number 3.
May I please, my lords? This is an application, my lord, for correction of some errors in the order, my lord. I have indicated in paragraph 2 of the application, my lords. Kindly direct correction.
One. All right. You see the errors pointed out in paragraph 2 of the application B. Carried out as indicated. Obliged. The corrected order be uploaded.
Item number 3.
May I please? Oh. Your Lordship. May I please, Your Lordship? Here, Your Lordship, just it is different from that Gita-Sri, Your Lordship, so far as that cattle. Here, Your Lordship, the question of law, Your Lordship, may kindly turn to page 14, Your Lordship.
What is the tax effect here?
Your Lordship, more. Your Lordship, it is 6 lakhs.
And is it covered by any judgment? That's what.
No, it is just different. Your Lordship has determined in that Gita-Sri that Chuni Chokot cannot be stated as category.
Correct.
Here, it has been stated that Brahman has been sold as category, so it is exempted. So far as the OST Act is concerned. So here, that judgment, I am taking help of that judgment. Independently, that cannot be said as category. And also, the entry here for the impugned period, the entry here is the brand. Previously, that was brand when sold as category is exempted. Subsequently, this has been amended and sold as category has been withdrawn, Your Lordship. So only brand is there, and here the brand was sold, Your Lordship. So for that reason, brand cannot be exempted from tax, Your Lordship.
All right.
So that is the entry, Your Lordship.
Where's the citation for that Gita response?
Your Lordship, Gita Sri, I am just
Gita Shri.
submitting the Gita Sri judgment. In this judgment, Your Lordship, at last paragraph 20, the court is of the view that chuni, which is a byproduct of dal, is not cattle and is therefore not amenable to entry tax.
Here you say it's brand.
Here it is bran, and Learning Tribunal has said that since bran has been sold as cattle feed, even the entry has been amended. So it is cattle feed and it is exempted as per the entry 30D.
All right, you say counsel for the Mr. Sunil Mishral and AAC for the CT and GST.
Your Lordship, in the
Well,
meantime,
standing counsel for the department states that the judgment dated 2nd August 2020. All this is not reported, is it yet? Of this court in STREV 31 of 2011, bracket State of Odisha versus Mrs. Geeta Shri Industries, bracket. Is in fact supporting the case of the present of the department as far as the present case is concerned, where according to him, the product involved is single quotes bran, unquote, which was in fact sold as single quotes cattle feed, unquote, and therefore according to the department amenable to entry tax.
Your Lordship, it is OST, amenable to OST. As per
Amenable to
OST,
OST, correct. Say notice returnable.
Your
24
Lordship,
July.
Your Lordship, yeah.
Item number 5.
Your Lordship, item number 5, Your Lordship, it is squarely covered by Your Lordship judgment. So far as that 40-5, Your Lordship might have remembered that
Right,
judgment of
right.
Chandrakant Jayantila.
Correct.
Your Lordship, 40-5, when that is mandatory, no discretion cannot be utilized.
Correct,
Your
correct,
Lordship. Here, Your Lordship, that is the question of law.
Anyway, we'll just issue notice then.
Your Lordship, here notice has been already been issued.
Oh, I see.
Your notice has already been issued, and Your Lordship, also notice has been sufficient. Late fee.
No, notice could not be issued
Your Lordship, already we have
due to
filed the-
requisites filed late.
Your Lordship, I'm sorry.
All right, the requisites filed late be accepted now for fresh notice to the respondent returnable. 25th July.
Item number 6.
Your Lordship, item number 6. It is a question of law, Your Lordship. I'm sorry, I could not get the covered judgment. Your Lordship may kindly look into at page 9. Whether the facts and in the circumstance of the case, the tribunal is justified in confirming the view expressed by the first appellate.
Zinc draws zinc. I thought this was also dealt with earlier.
Your
The zinc.
Lordship, not particularly the same, but identical. Your Lordship,
Yes,
to
yes.
some, I'm sorry,
Correct,
yesterday
correct.
evening I could not found out.
So you take time with
Your
filing
Lordship, Your Lordship.
at the request of Mr. Mishra, Learned Counsel for the department. List on
I'm sorry, Your Lordship. No, that's all right.
27 July. All right.
Item number 7.
Your Lordship, this item number 7 is also identical. Your Lordship, so far as that penalty under section 40-5, Your Lordship.
All right.
And here exactly the same thing, so far as the suppression has been confirmed, though so far as the additional quantum addition has been confirmed.
40-5 penalty
Only-
is paid by the opposite party.
Already paid.
Already paid.
Then there's nothing remaining.
Your Lordship, only question of law is to be decided.
Yeah, that will be
Only that
decided.
is covered. That
Counsel for the SSC states that the SSC has already paid the penalty on the basis of the demand under section 42 bracket 5 of the OVAT Act. That view of the matter, the question of law raised in the present petition is left open for decision in some other case. The revision petition is dismissed.
Item number 8.
My lords, item 8, your lordship was pleased to issue notice on 2011-2022. My friend says that he has no copy. I will serve a copy today
copy has
itself.
not been served.
All right. The copy of the petition be served on the standing council of the state today itself. List on same 25th July.
Fine.
All right.
Item 9.
Your Lordship, item number 9, Your Lordship, look into the question of law, Your Lordship. at
This
page 60.
thing went into that insolvency process, isn't it? The respondent.
Your Lordship, perhaps it has been backed. I think Mr. Das, day before yesterday, mentioned in one matter that built graphic, whether this Balarpur industry, that I am not sure.
No, it is.
Built is Balarpur.
Yeah,
It is also Balarpur. Your Lordship, day before yesterday, in one matter, he has stated that already returned, not successful before CIP proceeding.
Okay.
So
You want to just confirm that?
Your Lordship,
Mr. Mishra seeks time to ascertain if the opposite party is still subject matter of any corporate insolvency resolution process. That is a request list on 25th July.
Item number 10.
Your Lordship, item number 10, this is the penalty so far as 42.5. What happened here, Your Lordship? Section 42.5, Your Lordship knows very well that is a mandatory penalty. Your Lordship. On dated 1/10/2015, section 42.5 penalty as well as section 43.2 penalty, both have been amended with effect from 1/10/2015 to one time, Your Lordship. Before it was 2 times penalty.
I think fresh notice will have to go because the AD card has not come back. This is a katak. Why don't you take Dasti?
Your Lordship.
All right. Fresh notice through Dasti be served on the opposite party. Returnable on 1st August. Sorry, 1st August. All right.
Second,
Item 11.
Your Lordship, 11, same notice, same, sorry, 11 is a different party.
SN Traders.
Who appeared, no one appeared, but neither postal AD received back.
Same issue.
Same, Your Lordship.
Fresh notice. Dasti in addition.
Your Lordship.
Same date.
Item 12.
Same, no?
12 is same, Your Lordship.
All right. Same order in 12.
Item 13.
13, Your Lordship.
Again, after
Postal-
notice. All this
Your
is
Lordship.
after notice.
Your Lordship. Item number 13.
Postal tracking report has been served. Confirmed. Delivery has been confirmed. What's the question of law here?
Item number 13 is the question of law, whether on the facts and in the circumstance of the case, it is held that technicality would not stand as a bar for claiming input tax credit on stock of goods claimed to have been available on 1/4/2005, the date of introduction of Odisha Value Added Tax Act, even though the assessee failed to adduce any evidence. In Form VAT 607 and VAT 608, drawn contradictory to the provision contained in Section 107, read with Rule 123, framed thereunder. Your Lordship, this only question can be admitted, Your Lordship. All other questions are identical questions.
All right. We say admit the following question is framed for consideration. Take question 1, page 25. And then you say the record of the assessment record will record.
Your Lordship, assessment record I can produce, only tribunal record.
Or
LCR
record of the
not-
LCR of the tribunal be requisitioned. List for final hearing on 11 September.
Yes.
Item 14.
Your Lordship, can it not be August?
It's all right, doesn't matter. Yes,
Around, this is a PIM
yes.
where the Bogayat has been captured by the opposite party number 18, 8 to 15. Those are the builders. So Lordship may kindly come to page 18. That is 1963. The entire plot was deforested by the builder and the other co-villagers.
All
In
right,
this
the
regard-
petitioner's representation, packet annexure 7. You made this representation only on 26th April.
Previously also the written complaint is there, your lordship may kindly come to page 37 annexure 4. This is the Odia vernacular on dated 9/4/2022, your lordship. And that in that respect, the Pahalo IIC Pahalo also registered it in a case diary.
Okay, and
Yeah,
after
annexure
notice the
5,
petitioner and opposite parties 8 and 9. 8 to 15. A reasoned order shall be passed not later than 14th August and be communicated to the parties within a week thereafter. Court clarifies it is not expressed in the matter.
Lord, I have filed one this case, IA, for enjoining the opposite party number 8
It's
to
all right.
15.
It will be open to the petitioner to approach the collector for interim orders. All right.
Item 15.
None appears dismissed.
Item number 16.
Scheme Lord has instructions to appear for the respondent.
Ah.
Here the single judge's matter
Prior to
order
it, it's
Lord,
my
has been
appeal.
complied here, has been complied with 2 years back.
Oh, I see.
And
My
this
lord,
similar matter,
I'll come
which
to
was
that, I'll
yes, similar matters which was filed by the university Lord, has been disposed of on the 26th of last month.
Oh, I see.
And now laws here, the defects have also not been removed.
All right.
So this has come before removed it.
Okay.
And the respondent number 1 my lord is now 85 years old. My lord. He needs some peace.
We'll leave the question open.
No, my lords. Fraud has been played on the court, your lordship. One document I'll
It's a
If my learned-
it's a
I have never
the Vice
seen-
Chancellor and the Chancellor.
I have never
The
seen
Vice
my learned
Chancellor comes up
senior
with- no, my Vice Chancellor comes
be
up
this
with-
aggressive unless he has something to hide, my lords. I have
I have
never
nothing
seen
to
it.
hide. I have nothing to hide.
Annexure 2, my lords.
Respondent number one.
Annexure 2, your lordship may see. Just your lordship, how records have been manipulated.
Let them know.
Page 44, the record of this court has been manipulated. Record of this court has been manipulated, annexure 2 on the face of it.
We've already disposed
My lord,
of one appeal.
My
Against the
lord,
same matter, we can't have.
No, Chancellor was never heard. Your lordship will see page 45, 48.
The Vice
Opposite party,
Chancellor and the university
kindly, sir, kindly
for
allow
11
me,
years, Lord, no
kindly
counsel
allow me to
is filed.
submit.
No, for 11 years, Lord.
I'm sorry, my lord, she's not allowing me to speak. What is this?
Yes.
Page 48, my lord. Lordship will see, they have made the chancellor, opposite party number 3, Chancellor Utkal University, the governor has been made a party. Then, my lord, your lordship will see come to page 44. Your lordship has 48, opposite
Yes.
party number 3.
Yes.
Now, my lord, page 44. How, my lord, records of this court have been tampered? It was filled up. The notices were initially filed against the chancellor. Then, my lords, in another handwriting, the notice has been redirected to the vice chancellor. So it's a game which has been played amongst themselves. And one day prior to the retirement, the man is being appointed to a substantive post as a professor, and he retires as a professor one day prior. And my lord, your lordship will see substantive. I'm sorry.
No, what was the issue? That's not clear. What is the issue?
The issue,
Well,
Lord, let me
issue
put it
is-
up. Issue is
issue is this, annexure 6.
Retired as a professor.
Annexure 6
2
is the
years
issue,
thereafter,
page
Lord,
80.
Not 2 years thereafter.
Page 80 is annexure 6 is the issue, my lord. That in pursuance to the orders passed by the vice chancellor, after telephonic discussion with the principal secretary to the chancellor, Rajbhavan Orissa, Dr. S.P. Bhuiya, erstwhile professor of zoology, was allowed to hold the office of the director of academic staff, is temporarily revived, so and so, and he was working as a lien vacancy. Is my lord's on a telephonic, my lord's, discussion on in a substantive post, my lords. This is complete subterfuge. Lordship will see my grounds. Page 17, my lords, ground number 2. No advertisement was made, no select list was drawn, no sanction was obtained for the advertisement. There was no reason to appoint him, no selection procedure was followed, no appointment was done purportedly on the basis of a telephonic intimation. And this is how, my lords, the
No. If you see the implementation order, it doesn't say it's subject to anything.
No, implementation was ordered. I was kept out of the game.
But you can't. How is he supposed to know all that?
My lord, chancellor was.
How can this is something between the vice chancellor and you, obviously. As far as this person is concerned, how is he
Vice
concerned with
chancellor
all
was
that?
not even a party to the dispute. That is the thing, my lord. The vice chancellor
Vice Chancellor
was not
the
even
registrar.
a
Vice
party.
Chancellor,
The
registrar, no, they were party.
registrar
They
is a
appeared,
party. What was the necessity to redirect the notice of the chancellor to the
In
vice
fact, there's a
chancellor?
contempt case. Pursuant to the order, the contempt was implemented.
My lord, the chancellor remained out.
That's all right. You see,
I leave it at that. I leave it at that. I would leave it at that. Once your lordship.
against the same impugned judgment, Utkal University had filed WA number 491 of 2021, which was heard with this court on 26th April 2023. So this court was shown copy of an office order dated 18 March 2021, issued by the registrar, Utkal University. Restoring the professorship of respondent number 1.
No, not restoring manners.
It is-
Appointing.
No. This is restoring, sir. The word
Because
is used.
he was appointed.
So
against
this
the-
order, please see this order. The implementation order. Pursuant to the order passed on 17/11/2019 in contempt case number 2390 of 2019 and the impugned order dated 10/1/2019 in WP civil number 15472 of 2007. Full stop. The said office order was not made subject to any other pending proceeding. Full stop. Taking note of the above development, WA number 491 of 2021 was disposed of as having been rendered infructuous. Paragraph. The present appeal is by the Chancellor of the same university. Full stop. Considering that the respondent number 1 is already 86 years old and an order has already been passed by the university implementing the impugned order, the court sees no reason why it should entertain the present writ appeal.
One line that it was forcefully
Full stop.
pressed. Writ appeal was forcefully pressed. To absolve me of professional.
No, it's all right. Consequently, notwithstanding the submissions made by learned senior counsel for the appellant, that this court should nevertheless entertain the writ appeal,
Grateful.
that plea is declined and the writ appeal is disposed of as having become infructuous.
Grateful.
Item 17.
Some piece in this twilight lengthy.
Item number 17.
Pardon to appear through virtual mode, my lord. Item 17.
Yes.
Lordship, the counsel for the appellant is not able to come because of some family difficulties. Kindly request for some other date.
This is as it is listed on its own, sir. Tell us what the matter is about.
Such a senior counsel is not present, so I don't know the matter. I was asked to take a date.
That's not the reason, sir. Please. Just see what it is about. 2811.
Matter has been remanded to the revisional authority.
That's it.
So,
The challenge in the present writ appeal is to an order dated 8 November 2021 passed by the learned single judge, disposing of OJC number 8631 of 1999, whereby, while setting aside the order dated 6th December, order dated 18 June 1998 of the Joint Commissioners Settlement and Consolidation Odisha in consolidation revision case number 201 to 204 of 1995. The matter has been remitted to the said authority for a fresh adjudication after giving opportunity of hearing to the parties concerned. Full stop. It is likely that pursuant to the above order, the authority has already considered heard the regime cases afresh, and if not already disposed of, is directed now to dispose it of within a period of 6 months from today. Stop. No further directions are called for. The writ appeal is disposed of. A copy of this order be sent to the Joint Commissioners Settlement and Consolidation Odisha, Bhubaneswar, forthwith.
Item 18.
Item 18, my lord, on behalf of Mr. Bear, outsourcing matter.
8th August.
8th August.
All right.
Item 19.
19 dealer 25th September.
Item number 2.
You all have to say issue notice, all that, and stay in the meanwhile.
Item number 20.
2021 works at 14th September.
14 September. All right.
Item 23.
23 to 36 well, 24th of July.
24th July. All right. 23 to 36.
36.
Oh, the whole batch.
Item 37.
37 infructuous.
Disposed of as infructuous.
Item 38.
May Lordship, page 96 is the input order. The direction is at page 101, my lord, paragraph 5.
So you've not taken over this
No, my lord.
dispensary yet.
No, my lord, because your lordship is 103 annexure 4. This is the criteria for taking of charitable homeopathy institution by the government. Your lordship is the clause 3.
$50 of dispute-free land.
This is the only one mandatory condition. It is the admitted fact that charitable homeopathic institution are 10 decimals of land.
Is there any contempt petition here?
No, ma'am. Yes. This is the order, my lord. 12/7/22. So no information on contempt.
Say notice returnable. 16th August. Notice on stay.
Item 39.
The soft copy of the writ petition civil 4919 of 2016 be included in the record.
Item 39.
Lordship, turn page 29, the input order. That the Honorable Singular has relied upon its notification. Lordship, page 30, paragraph 4. It appears from paragraph 14 in the counter that circular relied upon by the petition is also relied upon by the department and calling the same clarification by letter dated 25th September 2012. By that circular, untrained teachers were to be given regulation upon their completing 3 years of satisfactory service. The condition was training to be obtained thereafter by 31st March 2015. Petitioner in paragraph 6.2 and 6.2 asserted that he completed his training as on 20th February 2015. There is no specific denial of the assertion as in paragraph 4 of the ground also. The read petition succeed prayer is allowed passing the setting aside the input order dated 24th November. The benefit to be paid to the petitioner the same in Annex 5, the read petition being officer or so and so. There must be complaints.
So what is this ventilate the legal truth? What does this mean? You're not answered anything. What is this? You've not answered, you've not answered, sir.
What it means, Mala, that they will be regularized in.
It's all right. It's all right. You see, the perusal of the impugned order shows that in the counter affidavit filed by the appellant state, there was no specific denial of the assertion by the respondent number 1 that he had completed his training as on 20th February 2015. With there being no specific denial, the learned single judge was justified in proceeding on the basis of the correctness of the above.
That to fact I am trying. That 3 years training, there is no dispute, my lord. I'll show only one line, page
36.
Page 30, first page 33, 34, 33, man.
Yes.
Clause 4.
Yes.
the trained junior teachers after completion of 3 years of continuous satisfactory engagement as such under Jilla may be eligible for appointment as a regular teacher. So this is the condition. You'll also see the date, what are the 1/8/2011 this circular is issued. So a clarification was issued that page 35/6. Page 36 second time. In order to overcome such discrimination, the government after careful have decided that all untrained junior teachers who have completed 3 years as on 31/7/2011 prior to issuance of resume may be appointed as regular. So that was the cutoff date. If he has completed 3 years as on 31/7/2011, then he will be regularized as a primary school teacher. That was the cutoff date. He completed 3 years in 2013. So that, and second, you also may see page 37. There are the next condition that you have to.
But why don't you file a counter pointing that out?
That circular we have annexed.
No,
That
mere circular. I mean, somebody has to explain to the single judge, right?
That was the circular, and we have relied because that 3 years stipulation we have stayed. Because admitted fact he has completed training, but he has not completed 3 years as on the 1/8/2011.
It's pointed out that in terms of the relevant circular, the 3-year training had to be completed by 31st July 2011, and therefore the respondent was ineligible for the benefit of regularization. Is it?
He has been regularized after 2015.
Regularization prior to that date. All right. Notice returnable. September. Notice on stage.
Item 40. Sorry.
This is the job contract 14th September. 14th September.
All right.
41 job contract. 14th September.
Yes.
Item 42.
42 मतलब Hindi teacher that yesterday's matter 18th September 18/9 on train back.
Item 43.
43 also job contract 14th September.
14th September.
Item 44.
May it please, Matt. Let the input order will Lordship will find at page 49.
That's right. Correction of date of birth.
Well, there is conclusive evidence, all on record. There was an inquiry. In the inquiry, the date of birth was found to be conclusive. There is nothing more to be adjudicated.
No.
And it has to be only seen that whether it's entitled to the benefit of
Supreme Court is very clear.
No, yes, I have brought Supreme Court judgment. If there is conclusiveness in the the date of birth, there is no shroud over it. Lordship just sees 3 pages, page 26.
Okay, what you've already superannuated or you've not?
Yes, superannuation. After getting the superannuation notice, I came back. But Lordship just sees 3 pages, page 26.
Yes.
On the basis of the letter of my employer ballot, it went to the Board of Secondary Education. The Board of Secondary Education at page 26 said my date of birth is 5/12/1966. It will again.
What does the service record show?
Service record was it was 62. After I came to know that 14 years prior to my retirement I have given. Not that at the fag end. And let me kindly see what was the reason for the wrong recording at page 38. Thrice it has come out as 66. Page 38 last para.
Yes.
However, in this case, while receiving the original pass certificate at the camp in the year 1983, the correction in the date of birth of Sri Shetty has been made by the concerned camp officer of the board on the spot in the certificate of registrar or tabulation register, and also in the original pass certificate as 5266 as per the cancelled TC so and so submitted by the headmaster at the time. So every after this also says the according to 5266, all records made conclusively. There is not a single departure that my date of birth is other than 5/12/66. No departure. Well, this is second page, and thirdly, Lordship will kindly see at page 30, 30, my lord. Again, my lord, the authority they said it is 5/12/66. But there is no departure, my lord. And I have given 14. What the Supreme Court said, Lordship has rightly said, my lord, there are 3 judgments of Supreme Court. The latest being, my lord, AIR 2011-3418. Well, in paragraph 10, my lord, their lordships took note of a judgment of 1993 Supreme Court, which is in regard to, my lord, whether injunction could be granted in case of someone approaching the court at the fag end of the career, my lord. But here in lordship in paragraph 10 has said, my lord, their lordships not said. Lordship may just see, my lord. I have given the tick mark.
All right. Counsel for the petitioner relies on the judgment in state of MP versus Premlal Srivas, AR 2011 SC 3418, where in para 10, a passage has been quoted from Secretary and Commissioner Home Department versus R. Krivakaran, 1994, Supplementary 1 SEC 155, to the effect that interference would be justified if there is a clear case. No, on the issue of date of birth, interference can be justified on the basis of open quotation materials which can be held to be conclusive in nature. Unquote. It is argued that from the records of the respondents themselves, it can be established in the present case that the appellant's date of birth would be 6th December 1966. And therefore, the single judge, learned single judge, ought not to have relegated the appellant to the remedy of the civil court. Remedy before a civil court, full stop. You say notice returnable. Notice is accepted by Mr. Kunti on behalf of respondent number 1. Notice will now issue to respondents 2 and 3 by registered speed post with the tracking report be placed on record by the next day.
I have handed over the copy now to Mr. Kunti.
Mr. Kunti has been handed over. All right. Placed on 5th September.
Item 45.
Item 45, my lord. Para 13 and 14 of the opinion and also para 15 in the reputation, I have related the covered case, my lord, where the commissioner cannot delegate its power to the Tahsildar. Commissioner decide. Here the commissioner has remanded the case open remand, and this point has not been taken into consideration by the learned single judge. In also in ground number 2, my lord. At the implemented annexation and consequence order, the commissioner has decided the case, not decided, kept open for the Tahsildar, page 25 of my writ petition, where the commissioner has remanded the case to Tahsildar for adjudication. 15B cannot be delegated to Tahsildar. It is power of the commissioner. It has been decided in this case.
Let me see the order.
Copy has not been served. Let me see the. No. Order of the commission.
Oh, you serve the paper book now. You just say a copy of the paper book be served on counsel for the state for enable to take instructions. List on. September.
My name may be reflected.
All right.
Item 46. 46 job conduct 14th September. 47.
What is this? This.
I will take it on after that.
Which one? 47.
I am for the opposite party.
All right. At the request of counsel for the opposite party. List on. August 9th.
Item 48.
Item 48, your Lordship might have remembered that issue that so far as the levy of tax, your Lordship, claim of ITC on chemical, your Lordship. Whether chemical, your Lordship, the identical matters, your Lordship, was the adjourned cyanide. So far as since the issue is before Honorable Supreme Court, your Lordship.
All right.
The Nalco and Bhushan and all, whether raw material.
All right.
Chemical is a raw material or not. The question of law is at page, your Lordship, page 19. Question A. B, I think B is in favor of the petitioner, but is in favor of the dealer, your Lordship, opposite party. Your Lordship has already decided that issue, so far as the B question is concerned. So far as the A is pending before Honorable Supreme Court.
All right. Is a notice confined to. This is after notice, right?
Your Lordship.
All right. The notice already issued is confined to. Question A. That is, take from bottom of 19 and top of 20. Paragraph. On the above issue, it is stated that against the judgment dated 19th April 2021, STREB 31 of 2012, bracket National Aluminium Company Limited with the state of Orissa, bracket, an SLP has been filed with the state, which is pending. Full stop. Likewise, the SLP against the decision of this court in Bhushan Power and Steel Limited versus State of Orissa 2012 56 BST 50 bracket Orissa is also stated to be pending the Supreme Court. Paragraph. In that view of the matter, the present petition is adjourned sine die, awaiting the decision of the Supreme Court in the above SLPs. Full stop. Liberty is granted to the parties to mention it for listing after the decision of the Supreme Court.
Item 49.
Let's see, item number 49. The question of law is at page. Yeah, let's see, page 14, 1-4. Okay, let's see whether in the facts and circumstances of the case, in absence of notification.
Who's for the other side? This is already admitted.
Yeah, let's see.
None is appearing on behalf of the opposite parties. Registry will inform counsel whose name is shown for the opposite parties to remain telephonically to remain present at the next date. 18th September.
Item 50.
Your Lordship, this item Your Lordship, the question of law is at page 13. Whether on the facts and in the circumstances.
Now, what happened to notice issued?
Your Lordship, notice has been issued. Or Your Lordship, on dated 22nd November 2022.
All right. You see, despite service of notice, none appears for the
Your Lordship.
respondent.
Your Lordship.
Admit the following question is framed for consideration. Which page?
Page 13.
One is enough?
Your Lordship, Your Lordship, A, B, C all are identical. Your Lordship, all the questions may be, and all.
Then B is enough then?
Your Lordship.
All right. Question B. Question B is enough.
Your Lordship. Yes.
Question B. This for final hearing. The LCR of the tribunal be requisitioned. Record of the tribunal, sorry. Be requisitioned. List for final hearing. 18 September.
Your Lordship.
51.
Your Lordship, item 51. Your Lordship, the same as like 50. The question of law is at page 11.
You're there.
Your Lordship. Your Lordship, this petition is not at a mental level because the issue before Your Lordship is by what agitated by the state. So whether this contract executed by this respondent here is covered under the execution of was contract or it's a sale contract. Your Lordship can have a glance to the nature of the contract and the
Sir,
contract.
let me argue first. It is my,
Yes,
it is
yes.
my revision. Here, let's see. The question of law is at page 11.
Yes.
Whether on the facts and in the circumstance of the case, fail in error in treating contract of artwork information involving clearing ground, stocking of art from railway land, supply of art by contractor from other sources, supply of morum and spreading it over the art formation, and mechanical compaction as was contract. Whether on the facts that the B is sufficient, but I think whether on the facts and in the circumstance of the case, contract of artwork information involving clearing of ground, stacking of art from railway land, supply of art by contractor from other sources, supply of morum and spreading it over the art formation and mechanical compaction is sale of goods accessible to tax at the rate of 12% under 105 of the schedule of goods, subject to levy of sales tax at the rate of 8% by virtue of finance department notification dated so and so. Your Lordship, and also question number C, it is identical, Your Lordship. These two judgment, same railway contract, Your Lordship, may kindly look into these two judgment. One of this Honorable High Court of Orissa in PK Satpathy case, and in another judgment of Honorable Karnataka High Court in case of HK Jadhav, Your Lordship. These two judgment, basing on these two judgment, is covered. Your Lordship, the sale or was contract in PK Satpathy case, Your Lordship, this Honorable Odisha High Court, sale or was contract, taxable turnover contract with railway for supply of hard broken ballast in stock at specified depot. Royalty to quarry owner, handling and loading charges to be borne by contractor, and contractor was owner of ballast property. Same, here is the spreading of ballast, Your Lordship. Spreading, stacking of ballast, here is the art, Your Lordship. And Your Lordship, same contract in also in case of that HK Jadhav, Honorable Karnataka High Court. Honorable Karnataka High Court clearly stated at Your Lordship at page 208.
Your
Are you
Lordship,
ready with all this case law?
Whatever the case law my Lord friend is citing, already that has been dealt with by the tribunal. Your Lordship can have a glance to the running page 31.
We'll
The
hear
tribunal
it finally
order.
then. We won't hear it today. We'll hear it finally.
Your Lordship.
You say, admit the following questions of law framed for consideration. I think one is C is enough, sir.
Your Lordship, B and C.
C is enough.
Same,
C.
Your Lordship.
One of them you choose, B or C.
Your Lordship, then B. Only
All right,
judgments
B.
are reflected
Right.
in C.
Only B. The record of the tribunal be requisitioned.
Yes, you.
List for final hearing. 27 September.
Item 52.
Lordship, this item 52, this is that reopening of assessment under section 12(8), Your Lordship, it is somehow covered. But here, Your Lordship, the record is required.
No, but you're not, the 52 is somebody else.
Your Lordship, I'm for the opposite part. Sorry.
Item 52.
None appears to the petitioner. Dismissed.
Item 53.
Item 53, Your Lordship. Your Lordship, it is my appeal. It is saying section 42(5) penalty.
Ah,
Your Lordship may kindly look into the question of law at page 20.
there's only one question.
Only one question, 42(5), Your Lordship, it is,
Correct.
it is, and also my learned senior is appearing in this case, so it can be disposed of. Since it is covered,
My lord, the case of State of Orissa Chandrakant of Joypal, your lordships, my lord has held that under section 42(5),
No
the
discretion.
levy of penalty automatic, mandatory, and not discretion. While answering a question of law, whether the tribunal has committed an error or not by deleting the penalty on the levying the penalty on the tax assess, your lordships. But this is not the case, your lordship. I am not being covered by Chandrakant, your lordships. Rather, I am covered by my lord's order in the Durupage limited, your lordships, wherein my lord has held that on the added tax liability, the penalty is not leviable under section 12(3)(g), but is leviable with the interest, your lordships. Let me share both the judgments of my lords.
Your Lordship, that 12(3)(g), Your Lordship might have remembered, Commissioner himself has withdrawn that penalty. Your Lordship, on that withdrawal, Your Lordship, we have considered that since the Commissioner has withdrawn, so far as that penalty is concerned, so penalty has been deleted, Your Lordship. And so far as that admitted tax, Your Lordship has disposed of.
That is sorry.
Here 12(3)(g) is not attracted.
CST.
My lord.
Here there is no CST, it's OVAT.
My lord, the language of both the section 12(3)(g) and 42(g), your lordship, perimeter are identical, your lordship.
No.
Yes, perimeter, my lord.
Why Your Lordship might have remembered why Your Lordship has confirmed, why Your Lordship has passed this judgment. Your Lordship is very well aware about the fact. Once there is suppression, once there is non-payment of admitted tax.
Let me frame the question.
Your Lordship.
You say, just to admit the following question is framed for consideration. Just question 2 is enough. And you say, while learned counsel, the department relies on the judgment of this court in State of Orissa versus Messrs. Chandrakanta Jayantilal, Cuttack, 2023-108 GSTR 81 bracket Odisha. Mr. C.R. Dash, learned counsel appearing for the SSC respondent, opposite party SSC, places reliance on the orders dated 14/12/2022 of this court in STRAV 36 of 2017 bracket Duro Pipes Private Limited, State of Orissa, and the order dated 7/12/2022 in STRAV 9 of 2016 bracket Messrs. Lakshmi Narayan Bandar, Cuttack, State of Orissa. Paragraph. Both parties will file their respective written notes of submissions. The record of the tribunal will be requisitioned for the next date. List for final hearing on 27 September.
Your Lordship, all these cases are covered case, Your Lordship. At
all
least,
right.
at least in the month of June.
My lord is
Your
not
Lordship,
covered,
Your
your
Lordship,
lordship.
because all these
If
can
I
be
given
disposed
10
of.
minutes time, I can convey my brother. I am not being covered by under Chandrakanta.
All right.
54. Get to my lord.
54.
It's the department appeal matter. In this case, my lord, your lordship's judgment is prior to the admission of this matter. It is covered by your lordship's judgment. Khadi Kaju Industries case, my lord. It is covered.
All right. The question raised by the revenue in the present revision petition stands covered against it by the judgment dated 15/12/2022 of this court in STRAV 96 of 2017 bracket Messrs. Mark Hadi Cashew Industries versus the Commissioner of Commercial Taxes. In that view of the matter, the petition is dismissed.
Next item, same, my lord.
Same in the next one. All right.
Then, item 56, my lord.
56.
56 in matter. Here is the matter where the department is before my lords as against the order of the London Tribunal, man. London Tribunal has deleted the penalty and remitted the matter to decide afresh by the assessing officer, man. While deleting the penalty, it has observed in case number 38 why the tribunal has deleted the penalty. There is no mensaria in the part of the assessment. He has not deferred anything. That's why the tribunal has deleted the penalty. My lord, the coming department come before this court for that penalty. But however, the matter is remitted back to the AO to make a fresh assessment. That is the final direction of the tribunal.
Here it's a state revision. But the question is whether the 9C type penalty under the Entry Tax Act, audit assessment penalty, whether that requires any mens rea on the part of the dealer or it's automatic.
Anyway, it's gone back. It's been remanded, he says.
That this has been held that mens rea is needed. So, my lord, apart from this Chandrakant Lal judgment, my lord, very recently, Honorable Supreme Court, well, my lord, I'm just
has held it's automatic.
Automatic. When the language says penalty shall be levied, if your lordship would compare 9C5 with section 10, section 10 requires, my lord, mens rea.
The Gujarat statute, same wording.
Yes, my lord, exactly, same perimeter provision.
You examine it. Counsel for the department seeks to rely on the recent judgment dated
I have quoted on the top the
17th April 2023 of the Supreme Court of India in State of Gujarat versus Messrs. Saw Pipes Limited, bracket known as Jindal Saw Limited, bracket 2023 SEC Online SC 428.
As you listen, your lordship judgment that Chandra. Thanks.
As well as the order dated 21/12/2022 of this court in STRV 118 of 2019, bracket Messrs. Nirman Udyog Berampur versus State of Orissa. Paragraph. Admit the following question is framed for consideration. E. I think question E is enough. I think B is enough. B is enough.
B. Yes.
Question B. The records of the trial will be requisitioned. List for final hearing.
B.
On September 13th. All right.
57.
Page 21. Right, Amendment Act 2015, the penalty has been reduced to 100%. Previously, it was 200%. So, the question is whether on the facts and circumstances of the case, the Odisha Sales Tax Tribunal erred by reducing the imposition of penalty by applying the amended provision of 43(2) by virtue of the OVAT Amendment Act 2015, which came into force with effect from 1/10/2015 by Finance Department notification. So, that's the sole question. So, Lordship would turn to the order of the tribunal.
This is after notice. What happened? No one appeared.
Yes, madam. Notice has been duly served.
All right. Despite service of notice, none is appearing for the opposite party. Admit the following question is framed for consideration. Take. I think one is enough.
The other question is that contention has not been raised, yet the tribunal has proceeded to decide this issue, my lord.
That's all right. Just question one is enough. The record of the tribunal will be requisitioned. List for final hearing. On September 12th.
58.
Is similar to that 56, that 9C5 penalty.
All right, same as 56, same date.
56 minutes.
All right.
From 59.
Similar issue, what's the penalty is under OVAT Act, 42(5) penalty. Similar, perimeter provision with VAT Act.
No, which is the item? Today there are several items.
That 56 same, but it's under OVAT Act. Kindly turn to the question of law, page 36.
All right, admit. I think question 1 is enough. Question 1 you take from page 36. The record of the tribunal will be requisition. List for final hearing on. This is after notice, right?
Yes, madam.
Counter also filed. All right.
Delay of 58 days, madam.
Delay condoned. When are the other 42.5 matters coming up? That 42.5 we fixed up, right?
Yes, madam. There are many matters, madam. We'll give him
11 September. All right.
Item 60.
Mr. Beura.
My lords.
Delay of 39 days, madam.
All right. Delay is condoned. What's the issue here?
Now, law it gets page 37.
9C3.
Yes, madam.
Lords, he has traveled beyond the audit report.
That's the.
That is the
ground-
findings.
The question is whether the assessing officer, while undertaking this audit assessment, whether he can ask for verification of the documents. That 9C3 itself uses the word other inquiry as he deems necessary. So, my lord, the transactions that has been verified by the audit team, my lord. So he has asked for some more documents in tune with that audit visit report, my lord. So that the tribunal has said, no, you have to limit to the audit report, my lord. But if your lordship would find, he has not asked for any other, my lord, under any other head, under the same head that the audit report has pointed out, he has asked for documents. So, my lord, the first question of law that has been framed is whether on the facts and in the circumstances of the case, the tribunal committed gross error of law in not taking cognizance of the provisions contained in 9C3 of the OIT Act, which has empowered the assessing authority to pause, within inverted comma, my lord, other inquiry as deems necessary.
My lord, this
After
is covered by judgments, my lords, that he cannot go beyond.
Where are those judgments?
My lords, let it come any other.
All right. On the issue whether under section 9, capital C bracket 3 of the Orissa Entry Tax Act 1999, the assessing authority can go beyond the scope of the audit visit report is one of the issues that arises for consideration in the present petition. Paragraph, counsel for the opposite party assessee seeks time to produce copies of the case law he seeks to rely on. List on 22nd August. Yes.
Starting here, Lordship. May I make a?
Yes, yes.
My lord, we are facing difficulties with regards to writing of awards in the center. There is no hardly 1 or 2 stenographers.
I see. I see. Okay, I'll examine that. I'll examine.
At least I am waiting to. It is very security risk will be there if I do it in my chamber. I am not. That is why.
All right.
It will
All
come
right.
and coming, my lord.
All right. I'll look at it. Okay.
Yes, sir.
Due to pending of 482 petition of before this honorable court, trial court not taken the criminal case.
What is it? I don't know. What is this?
CLM's matter.
You can wait. We'll just call out that list. We'll just when we call out the 482 list, you can mention that. Right now we're in the arbitration list.
Supplemental list, fresh admission item number 1, ARBP 1 of 2023.
Item 1, my lords, I appear for the petitioner. Now, my lords, I filed an additional affidavit bringing on record certain events. While the Section 11 petition was pending, they've gone ahead, they've appeared, taken notice. They sought time also on 2 occasions for filing a reply. They've appointed the arbitral tribunal in the meantime after accepting notice. So if that arbitral tribunal has written to me saying that you participate in the proceedings, I've informed them that obviously there's a petition pending over here. So
Why is the tribunal going on?
My lord, actually, when 11 petition is the pending, my lord, we cannot appoint an arbiter. Lordship appoint under the justice take care of that.
All right.
your lordships may keep it to another date. I'll just take instructions on, and if your lordships permit, I'll come back with 2 or 3 names if your lordships. Just for next week, 19th. It'll
19th is not possible. It will go beyond the vacation. At the request of counsel for the petitioner. List on.
May I pray, my lord? In this case, either I may allowed to file a objection to this.
But why are they going ahead with the arbitration? I don't know. He says they're going ahead with the arbitration.
Department stand is that they have taken some department arbitrator, which lordship is clarifying the other judgment.
Correct.
So that's why I'm suggesting my friend to search the name of Justice Ratha and
Correct.
appointment.
Correct. But he wants some time for that. So don't proceed with the arbitration. You see, we'll keep it at the opening date, 23rd June.
Deeply approached.
No further proceedings before the arbitrator appointed by the opposite party shall take place.
Deeply approached.
Item number 2.
Page 22 is the arbitration clause.
All right. Notice returnable. June.
Obliged.
Item number 3.
My lordship, today I have received the reply to the rejoinder. So I need to
Today, rejoinder affidavit on behalf of the opposite party is
reply to the rejoinder. So I need some time, my lordship.
What is the reply to rejoinder now?
My lordship, actually, it is regarding the jurisdiction of the arbitrator, where they have in 11.6, it was admitted that if both the parties agreed, then they can final the arbitrator. But without consent of other party, they have appointed the arbitrator. And last occasion, my lordship has stayed that proceeding.
All right.
So they have filed the reply to our rejoinder, my lordship.
All right. Reply to rejoinder has been handed over in court. It is made clear there will be no further pleadings in the matter. Counsel for the respondent, opposite party seeks time to examine the reply and make submissions.
My lordship, that is an interim order.
Yeah. Interim order to continue, list on 14 July.
Obliged.
Item number 4.
Item number 4, already we have received the counter. But it is in transit. We have
Your lordship has the order dated last order. my
Yes,
lord.
last chance is given.
On
We have received it.
Four
Only we have to upload and,
adjournments have been
the
taken by
original
them.
copy is on a transit. They have sent the Xerox copy one. That's why. Only 1 week time. Next week also.
There's nothing, no counter is necessary in this case.
Yes, it is necessary. That's why I
Absolutely
have
not
given
necessary,
time.
my lord. I'll just, if your lordships will bear with me for a minute, my lord, I'll just show to your lordships. Only the interest part remains to be paid to me, which is provided in the contract. The Supreme Court left it open to approach the appropriate forum for that. They paid the principal at the intervention of the Supreme Court. If your lordship takes the order of the Supreme Court,
Only next week, man. Next Friday also. Let's see. No issue. Next Friday.
May I please be heard, my lord? I beg to appeal for OP number 4. I undertake to file the wakalat.
Oh, who's OP number 4 now?
Hindustan Aeronautics Limited. Because they are not the party.
All right, counsel appearing for HAL states that he needs to file a reply. Mr. Padi assures the court that reply on behalf of opposite party number 1 will be filed positively on or before 19th May 2023. The reply of HAL bracket opposite party number 4 also be filed positively on or before the July 2023. List on 14 July.
Sir, Bhokta is appearing with me in this case. In the earlier case, Mr. Tripathi.
All right, all right.
Okay.
Item number 5.
My lord, in this case, just now I received the counter. I want to examine and file the
All
rejoinder.
right, rejoinder we file for the next day, 21st July.
Okay.
Item number 6.
The arbitration clause is at page 14, clause 8, my lord. They have filed a counter, my lord. So, my lord, lordship, they have not disputed the agreement in itself and only filed just a formal objection, my lord.
Lord, I appear for the opposite parties in this matter, my lord.
Yes.
But kindly have a look at, we've filed a detailed reply. In fact, my lord, this
What the reply?
filed and served on the last occasion. Lord, the application itself is premature because if your lordship sees the arbitration clause itself, which is clause 8, well, that requires a tribunal of 3 learned arbitrators. Now, my lord, the notice says that my learned friend has proposed 3 names and they have requested us to, my lord, consent to the names suggested by them. Now, my lord, that is a procedure as far as arbitration with a sole arbitrator is concerned. If there
If
are
you're agreeable, then I'll ask the 2 arbitrators to meet and appoint the 3rd.
No, my lord, there is no appointment. My learned friend has also not nominated any arbitrator.
No, I'm saying he will now nominate one of those 3 names. You suggest your name, we'll ask both of them to meet and appoint the 3rd. That will be the end of the matter.
Therefore, my lord, as far as this petition is concerned.
No, that's a super technicality. If you're saying we should have only a 3-member tribunal, he's agreeable. One of the names he will say which is his nominee. You give me your nominee and that's the end of the matter.
Lord, may I just say this? There is one more aspect to the case. Opposite party number 2 is not a party to the agreement. Therefore, my lord, the question of opposite party number 2 to become party to the arbitration proceeding doesn't arise.
Who's opposite party number 2?
He's the managing director of the.
That's all right. So they'll drop the managing director. That's all right.
Then, my lord, may I just suggest this? My lord, may I just suggest this?
Yes.
If the petitioner, my lord, sends a notice with their nominee, we will respond to that because
not necessary, sir. Not necessary. If you insist, it should be only a 3-member tribunal. They can choose definitely their own nominee. You choose yours. That's the end of the matter.
May I just show the clause itself? Kindly have a look at arbitration clause at clause 8 of the agreement. Just have a look.
It's 14 clause 8.
At page 14, my lord, clause 8.
Yes.
If any disputes, controversies, differences arises between the parties hereout of or in relation to this agreement or any breach thereof shall be finally settled by arbitration by 2 arbitrators, one to be appointed by each party.
Right now, you give me the name of whom you are appointing. You give them 3 names. You give me one of those names.
Lord, currently, I don't have a name. Lord, I don't have it. I don't know. I cannot indicate any.
No, we'll give you time. You communicate your name within 30 days, and then that name and this person will meet together and appoint the umpire within the 3rd arbitrator within another 30 days.
Lord, therefore, what I'm submitting is that this application itself was not necessary.
It has come. It is here. What is the point in not entertaining it? We might as well go ahead and finish this exercise.
I am not saying no, but just kindly consider this aspect. Lord, they wrote to us, they invoked the arbitration, they wrote to us. We sent a holding reply to them saying that we will come back to you. Lord, without waiting for our reply, in a matter of 2 or 3 weeks, they filed this petition, which itself is.
All right. Give me the name. All right.
My lord, learned senior advocate Shaktidhar Das.
Shaktidhar Das. All right. Counsel for the opposite party insists that under clause 8 of the agreement, there can only be a 3-member arbitral tribunal and not a sole arbitrator. Full stop. Paragraph. Counsel for the petitioner states that the petitioner's nominee would be Mr. Shaktidhar Das, senior advocate of this court. Paragraph. Counsel for the opposite party needs time for the opposite party to nominate. Right in the beginning, you say at the request of counsel of the petitioner, opposite party number 2 is deleted from the array of parties. The sole opposite party will now be opposite party number 1. And then you say this, counsel appearing for the sole opposite party states that he needs time for nomination of an arbitrator on behalf of opposite party. Paragraph. The opposite party is directed to nominate its arbitrator within a period of 30 days from today in any event, not later than 12th June 2023, and communicate the said name to both the petitioner as well as its nominee arbitrator. Paragraph. Within 30 days thereafter, both the nominee of the petitioner as well as the nominee arbitrator of the opposite party will meet and decide on the name of the third arbitrator. Paragraph. If thereafter the arbitral tribunal so constituted will proceed in accordance with law and fix its own terms. Full stop. The arbitration will take place. Where is the venue of the arbitration? In Cuttack. In Bhubaneswar. All right. The arbitration will take place in Bhubaneswar, Odisha. Paragraph. If there's any difficulty in carrying out the above directions, it will be open to either of the parties to apply for directions.
A venue lordship may fixed in arbitration center, if possible.
All right.
Yeah.
But Bhubaneswar, if the venue is Bhubaneswar, then the arbitration center is here. So let it be that. Let them fix their own terms. Not a problem. The petition is disposed of the above terms. All right.
Item number 7.
In this case, I have entered appearance for the Raurkela steel plant matter, and I pray for some time to file a reply.
All right. Reply we file within 4 weeks, rejoined for the next date.
It is not necessary, Your Lordship. Unnecessary to be relating with the case.
Yeah.
Madam, this is the first listing of after my appearance, madam.
Only
I appeared on 17th.
only dispute is they are not paying the genuine escalation.
I have not received any instruction, written instruction. I have not.
All right. 21st July. All right.
Item number 8.
In this case, I am for the virtual mode matter. I am appeared for opposite party number and I filed my Bhuklatra on 8th, but that my name has not been reflected well. Let it come in 2 weeks time for filing of the counter.
All right. The name of Mr. J.K. Mahapatra be reflected for the opposite party. Reply we file within 4 weeks, rejoined for the next date. 21st July.
Much obliged.
Item 9.
Item 9, my lord, I am appearing in virtual mode. Lordship, in this case, I am appearing for the opposite parties. I filed my Vakalatnama. I don't know, kindly give some time to file the reply.
Court fee still not paid, sir.
Already paid, my lord. Today. I have already paid.
Petitioner states court fee has been paid today.
Already paid, my lord.
What about the other defects?
So far as other defects, I don't
All right. Counsel for the opposite party seeks and is granted 4 weeks time to file a reply. Rejoined for the next date. It's on 28th July. Other defects be cured in the meanwhile.
Item number 10.
And 11 mallards has already issued notice mallards direction to the opposite party.
My lord, I am for opposite party number 2, my lord.
As
My
well
lord,
as
4 weeks time may be given to file counter, my lord.
All right. In all these matters, 10, 11 and
10, 11.
10 and 11. You see, counsel for opposite party number 2.
My lord, in item number 11.
10 and opposite party in item 11 seeks and is granted 4 weeks time to file reply. Rejoined for the next date.
Item 11, opposite party number 1. And this 2.
That's what.
And also the government mallard, they have to also.
Will also.
All right. In 10, you say counsel for the opposite parties seeks and are granted 4 weeks time to file reply. Rejoined for the next date. List on 28th July. In 11, you say counsel for the opposite party seeks time. Same. What? 28th July.
Deeply obliged.
All right.
I don't know, 2 memo 4 to CLM. CLM, pardon. After notice, my lord. Due to next week in 81.
I know. They put it all before the roster. Slips. All 482 matter slips.
Yes, ma'am.
May I make a mention, my lord?
Yes.
Item 88, I have received the counter. I will file rejoinder, my lord. I have got the documents also. That's the time.
What is 88?
Item 88.
My lord.
Yeah, let it be called out, sir.
Specialist stress admission item number 1, CRLMC 747 of 2021.
None appears dismissed.
Item number 2.
3, 4, not pressed.
Not pressed, dismissed.
Item number 5.
None appears dismissed.
Item number 6.
Item 6, I may be permitted to withdraw with the liberty. I filed a memo.
All right, permitting the petitioner to resolve these.
Item number 7.
None appears dismissed.
Item number 8.
May I please, my lord. Item 8, my lord, both the parties already settlement or already filed affidavit also filed.
I am applying the informant matter. The matter is already settlement between
All
the
right,
parties.
counsel appeal for the informant opposite party number 2 confirms that the disputes have been settled. He also confirms the affidavit filed on behalf of opposite party number 2. In that way, the matter takes from the prayer clause and all proceedings consequent that we have quashed.
Obligation.
Item number 9.
Item 9, my lord, not fresh.
Dismissed is not pressed.
Item number 10.
None appears dismissed.
Item 11.
None appears dismissed.
Item number 12.
My lord, item 12, my lord, my lord, Mr. Counsel, Mr. Uppal has been engaged from Delhi, but since the matter has come up today, my lord, may call this matter any date after vacation.
2015 matter, sir.
My lord, also 2021, there's also an application. My lord, there's an interim order in favor of the petitioners.
That's the whole point.
Yes, my lord, the trial is going on, that only that there would be no coercive action that has been directed. So, my lord, the trial is continuing. So, my lord, nothing is prejudiced to the informant and the other side.
Let the trial go on.
Yes, that, my lord, there is no stay on the trial, your lordship.
No, so why should the matter be pending then?
My lord,
all pleas you can raise at that stage, sir.
My lord, may I just request your lordships to kindly consider this any date after vacation so that
No,
Mr.
no,
Uppal
they're
can
very
assist
old
your
matters.
lordships.
These are very old matters.
Oh.
In the first matter, you say permitting the petitioners to raise all pleas at the appropriate stage, the petition is disposed of. And same in the second one. Interim orders.
Therefore, the
Audit.
Grateful.
Item 13.
None appears dismissed.
Item number 14.
Same order.
Item 15.
Same order.
Item number 16.
Put the prayer clause, same order.
Item number 17.
None appears dismissed.
Item number 18.
Same order.
Item 19.
Same order.
Item number 20.
My lord, the parties have settled the matter and the affidavit has been filed to that effect also.
I'm already appealing and filing an application.
Counsel of the opposite parties confirms that they have settled the disputes. Their affidavits are also on record. In that view, the matter put on the prayer clause and all proceedings consequent that we have quashed. All right.
Obliged.
21.
None appears dismissed.
Item number 22.
So the matter has been already settled between the parties.
Who's the other side?
It's not party, lordship, matter party.
Just say counsel for the petitioner produces the affidavit of opposite party number 2.
So the private opposite party is not. Opposite party number 2.
Two, which states that the disputes have been settled. However, none is appearing on his behalf. A copy be handed over to counsel. The state will confirm the factual position and inform the court on the next date.
Lordship, stay further proceeding my eye.
No. Let him first confirm it. Let's before the roster bench on 21st June. All right.
Item 23.
None appears dismissed.
Item 24.
The matter has already been compromised. My lord friend.
I have appealing for informant, my lord. I am also affidavit filed.
All right. Counsel appealing for the opposite party number 2 informant stands by the affidavit filed on his behalf, stating that all the matters have been amicably settled between the parties and they do not wish to proceed further. That is the matter. Take the prayer clause and all proceedings consequent that we have a question.
25,
None appears dismissed.
item 26,
Same order.
27,
Same order.
item 28,
Same order.
29,
Same order.
item number 30,
Lord, item 30 became infructuous.
All right. Dismisses and infractions.
item 31,
None appears dismissed.
item 32,
None appears dismissed.
33,
My lords, may it please, your lords. This is against, my lords, a reversing order, my lords, in a matter arising out of section 133 of the CRPC, my lords. Now, the case of the petitioner, my lords, is, my lords, that he purchased a property, my lords, from the present OP number 5 by a registered sale deed, my lords, which is under annexure 1 in the year 2017. Now, prior to that, my lords, the present OP numbers 2 to 4, who were the second parties in the 133 application, my lords, they had purchased, my lords, an adjoining area, my lords, which is, my lords, measuring acre 0.025 decimals, my lords, in the year 1998 from the OP number 5. Now, annexure 3 would be very relevant for this case, my lords. Now, after, my lords, purchasing the property in the year 1998, my lords, these OP numbers 2 to 4 had entered into a chuktinama, my lords, an agreement with the OP number 5 that they will use that particular stretch of land as, my lords, as a rasta or a road. But, my lords, violating that agreement, my lords, they filed for mutation, and in
This is all civil proceedings, sir. I don't know why you invoke 133 for all of this.
but, my lords, the revision
We'll clarify that it's always open to you to seek civil remedies. It is clarified that notwithstanding the impugned order dated 19 December 2021 of the Additional Sessions Judge Anugu, setting aside the order dated 11th August 2020 passed by the Sub-Collector cum SDM Anugu, under section 133 CRPC, it will be open to the petitioners to seek appropriate civil remedies in accordance with law. The petition is disposed of.
34,
Dismissed as not placed.
35,
None appears dismissed.
item number 36,
Same order.
37,
May I please, your lordship? Lord, in this case, the petitioner, while serving as a senior pharmacist in OMT dispensary, he is challenged the FIR, my lord, to be quashed, my lord, and annexure 1 is the FIR. My lord, here, your lordship may see that the medical officer used to prescribe the medicine from OMC dispensary, my lord. Here, she is the pharmacist, and the charge was made on 1/5/2018. That is the holiday when the petitioner was absent from the mines, my lord, because of the Labor Day. My lord,
all this will be a matter of evidence, sir. Alibi and all is a matter of evidence. Can't be in a 480.
No, one thing you also see, why I am making a false allegation? They have gone to Keonjhar, which is 300 kilometers from.
Charge sheet is in filed or not?
Nothing.
Not yet. All right.
Keonjhar is 300 kilometers from Cuttack, my lord. They say that on 1/5/2018, which is a holiday, they had been there.
At this stage, how can all this be examined? Evidence will have to be let, sir.
But because I was
anyway, you still charge sheet has to be filed after that charge, so you have enough opportunities to argue all this. All right. Permitting
charge sheet is not been filed, I think.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed. All right.
item 38,
My lord, the prayer is for question of the FIR, my lord, annexure 2, lordship, kindly have a glance. The matter has been amicably settled because the daughter-in-law has filed the complaint against the father-in-law. Petitioner is the father-in-law. With regard to a piece of land, my lord, that is the allegation. And by annexure 2 at page 15, my lord.
You can point this out to the trial court, sir. Permitting the petitioner to point to raise all pleas at the appropriate stage. The petition is dismissed.
Taking into account the.
Obviously, sir. Obviously. Right.
item 39,
Memo taken on record. Dismisses withdrawn.
item number 40,
And appears dismissed.
item 41,
May I proceed? My compromise is effected, my lord, by the petitioner and opposite
got the
party
opposite
number
party.
Alright,
two
counsel
matters.
for opposite party number 2 hands over an affidavit stating that the disputes with the petitioner have been settled and that she does not wish to pursue the matter below. He does not wish to pursue the matter. In that view of the matter, take the prayer clause and all proceedings consequent thereto hereby quashed.
Obliged.
Item 42,
None appears dismissed.
item 43,
Same order.
item 44,
Same order.
item 45,
Same order.
46,
Same order.
item 47,
Same order. In 47.
47, your lordship, the brief has been transferred.
It's all right. Nobody's appearing there. We say in 47, counsel petitioner states that the brief has been transferred. None is appearing on behalf of the petitioner. Put down her name for the opposite party.
Opposite party 2, yeah.
All right. Dismiss now.
Okay.
48,
withdraw and raise the point before the law and court.
All right. Permitting the petitioner to raise all please. All right.
item 49,
Item 49, liberty to raise all.
Raise all
please.
please. All right.
item 50, 50,
None appears dismissed.
item 51,
Same order.
52,
Same order.
item 53,
I am for the inform the matter to
Settled. All right. Counsel appearing for opposite party number 2 hands over an affidavit stating that the disputes with the petitioner have been settled amicably and that they do not wish to proceed with the matter. Accordingly, take the prayer clause and all proceedings consequent thereto hereby quashed. All right.
item 54,
For item 54, I've given a declaration that there is a criminal revision pending 795 of 2014. I may be permitted to raise all my pleas in the criminal revision.
All right. Counsel, the petitioner seeks leave to raise all pleas raised in the present petition in the pending criminal revision case number
795 of 2014.
795 of 2014. Granting the liberty is prayed for the petition's disposal.
55,
None appears.
I'm appearing on behalf of Pratik Das, but I don't have power in this.
All right. All right. Right.
55,
None appears for the petitioner. Dismissed.
item 56,
Same order.
57,
Same order.
item 58,
Same order.
59,
Same order.
item number 60,
60, my lord, it's a matrimonial dispute. So I don't have the presence status about the case. So your lordship may grant me liberty
To raise all
if,
pleas.
cause of us.
All right. Permitting the petitioner to raise all pleas.
61,
None appears dismissed.
item 62,
May please alert. All the points raised before time.
All right. Permitting the petitioner to raise all pleas.
item number 63,
63, my lord, it has become infructuous because in the meantime trial has been concluded and he has been acquitted.
Dismissed as instructions. All right.
item 64,
None appears dismissed.
65,
Same order.
item 66,
Memo.
Number 66, not case.
Dismissed as not placed.
item 67,
Dismissed. None appears dismissed.
item 68,
I am appearing for OP2. Matter has been compromised between us, my lord. He is for the petitioner.
All right. Counsel
Flag A.
appearing for opposite party number 2 confirms
No, flag A, that was
that the
affidavit.
disputes have been settled. An affidavit to that effect is also on record. That view of the matter takes from the prayer clause and all proceedings consequent thereto hereby quashed.
Obliged.
item 69,
My lord, on behalf of Mr. Rock, may I pray for after vacation, my lord?
Counsel
Yes,
for
I'm
the
here.
petitioner stated, counsel for the petitioner stated to be in some personal difficulty today. It's on 3rd July. For
Yes,
the-
Item number
70.
70, may I please, sir?
Yes.
Sir, this case, the cognizance order dated 8/2/2021 is under challenge against the present petitioner, who is the MD of a reputed tractor company. And there is no iota of any sort of offense, the petition, the complaint that is revealed. Lordship, for a moment, I am taking lordship's attention to page 25.
page 25. That is the while the disposing 205 petition, the London magistrate has pronounced this order that I am reading the fourth para. On perusal of records, it is found that the MD of the Kubota Agriculture Machinery India Private Limited has not entered into any business transaction either in his personal capacity or in his official capacity with the complainant. No such transaction in the record shows the involvement of the petitioner in this.
All right. Just a notice returnable for the roster bench on 23rd August. There should be stay of the further proceedings in the meanwhile. All right.
Item 71. 71.
None appears dismissed.
Item number 72.
Same order.
73.
73, my lord, matrimonial dispute. Wife is the informant and does not want to proceed with the case. So
where is the affidavit?
My lord, affidavit, I pray for issuance of notice. I have taken the arguments.
Counsel, the petitioner needs time to produce the affidavit of the wife, respondent opposite party number 2 wife, about the settlement stated have been arrived at between the parties. At its request list before the roster bench on 13th July.
Item number 74.
May I please, Your Lordship?
Yes, please.
Lordship, being aggrieved by order dated 1st February 2023 of Family Court Burger, I have filed this application.
Yes.
In a proceeding.
What's the offense, sir? What is the offense?
No, Lordship, it is a matter of
125 CRPC. Achha. What is the amount ordered? 2,500. What is this amount, sir? Hardly any amount.
Excuse me, sir, it is not about the amount. It is about the misinterpretation of law that the lower court has passed an order.
It's only an interim order, sir. This is interim maintenance, correct?
You know, I have filed I filed this petition against the order dated 1st February 2023, filed annexation number 1, totally misinterpreting the law and judgment pronounced by the Honorable Supreme Court in Rajans versus Neha. This order has been passed against me. Jumping all the procedures of process of law directly, order has been passed, strike of my defense.
Let's read it. Read it, sir. Read the portion of the impugned order which you are aggrieved by.
Annexation number 1, sir.
Are you ready with the interim maintenance or not?
Yes, you know.
When were you asked to pay this 2,500, sir? On 21/10/22, correct?
Yes, sir.
And 1,500 towards litigation expenses.
Yes, sir.
So from 9/8, let's calculate 9/8/22 till May, which is 9 months, correct?
Yes, sir.
9 months you have to pay how much? 22,500.
Yes, sir.
Correct. So you pay this 22,500 plus 1,500 is 24,000. You pay her 24,000, produce before this court proof of payment, will issue notice. All right.
That's it.
Counsel, the petitioner undertakes that the arrears of interim maintenance as ordered by the court of the learned, by the family court on to be paid with effect from 9/8/2022 together with the litigation expenses 1,500, which works out as of date to rupees 24,000, will be paid by the petitioner to the respondent wife, opposite party wife, on or before 12th June 2023. Subject to the petitioner placing on record before this court in the present matter proof of such payment of cost, notice will issue to the opposite party number 2. Notice will issue the petition. He accepts for 1. Notice will be accepted by. Sorry, no. Just notice will issue to the opposite party. Returnable. 22nd June. It is made clear that the above payment will be without prejudice to the rights of the petitioner. Right. All right.
75.
May I please, Lordship? Lordship, in this case, I am applying for the OP number 2. In this case, I am also filing affidavit that matter has been amicably settled.
All right. Counsel appearing for opposite party number 2 has produced an affidavit stating that the disputes with the petitioner have been settled. But this is SC/ST Act. It can't be settled like this. Can't be settled. It's SC/ST Act. Can't be done.
The complaint not proceed to against the administration.
No. SC/ST Act. You'll have to approach that court only, sir. Can't be done like this. If you withdraw it with liberty to raise all pleas, just give it back. Counsel petitioner seeks leave to withdraw the present petition with liberty to raise all pleas at the appropriate stage of the trial. The petition is supposed.
Item 76.
Mr. Patra is ill.
All right. Counsel with the petitioner is stated to be unwell. Let's move for the roster bench on 17 July.
Item 77.
57, I have filed application for restoration, but I am filing somewhere. Can you take up after recess? I have somewhere kept the
All
file.
right. Counsel at the request of counsel with the petitioner list on 26 June.
Item 78.
26
June.
Item 78.
78, my lord, present petitioner is the husband. Here he has challenged the multiple proceeding. Lordship may kindly have a glance page 30. 30 order dated 3/11/2018. There is a divorce of decree has been awarded, my lord. 6 lakhs has been awarded, that has been deposited, and thereafter.
Who's appearing for the wife?
Our notice has already been gone, my lord.
No, but who's appearing? Siddheshwar Bagh.
Yes.
Where is Mr. Bagh?
Lordship, I am for opposite party in this case. We are not receiving the payment.
You're not receiving payment.
You already 6 lakhs deposited check, page number 32. I have already deposited the check.
Check is okay. That doesn't seem to have reached her.
Already.
Lordship, do
I'll if not, Lordship keep it after vacation.
one case pending in set aside petition in CRO Bhubaneswar Court with family court. One case is pending already.
All right. Counsel appearing for the opposite party states that the opposite party is not received.
I'll file a receipt.
Payment as is claimed to have been made by the counsel by the petitioner. Full stop. He states that he will provide the proof of payment to counsel for the opposite party.
That is permanent alimony, my lord.
All right. Proof of payment to permanent alimony to opposite party, counsel for the opposite party within 2 weeks. Let's go for the roster bench.
Obliged, ma'am. Interim order is there.
On 10 July, interim order to continue. All right.
Item 79.
No instruction from plan. No instruction from plan.
No instructions dismissed. All right.
Item 80.
None appears dismissed.
Item 81.
Permitting to raise all please.
Item 82.
22, the cause of action does not separate.
All right. Dismisses the cause of action does not.
Item 83.
No instruction.
No instructions dismissed.
Item 84.
Well, 84, I'm appearing through video conference.
Mm.
Well, here is a case where a criminal proceeding has been initiated against the petitioner.
Mm.
But actually, it's a civil dispute. Well, the facts like this: the petitioner is a dealer of Kubota tractors.
I am appealing for OP number 2, my lord. A clear case of cheating has been made out because your lords may kindly peruse the order of the magistrate, where the magistrate has said, peruse the complaint petitions and the statement recorded under section 202 of the witnesses, where a clear case of cheating has been made out. After being satisfied with the inquiry report and with the complaint, amending the complaint petition, he has taken cognizance, my lord. And no stay has been granted. The trial must have commenced.
No, the trial has not commenced, my lords. The facts are like this, my lords.
It's a clear case of cheating, my lord. Let him raise all the points in the lower court.
It is my case. The president doesn't understand my anxiety to place my own case.
I understand. I understand your anxiety, but the case is not in your favor.
Yes.
Yes, let me place it, my lords. Thereafter, whatever he has to say, he has already stated.
All right, all right.
My lords, I am a dealer of Kubota tractors, my lords.
Right.
Now, my lords, I have a firm under the name and style of Nigamananda Associates.
Right.
Now, what happens? The petitioner comes to me, the opposite party number 2 comes to me and deposits a sum of rupees 7 lakhs. Says that is an admitted position, my lords. It has been given to me by check, my lords. There are bank transactions. 7 lakhs has already been given. And my lords, he says, I want to buy a harvester. So, my lords, I assure him that yes, I'll take financial. And when we go to the financial, we find out that his CIBIL score is very low. So, it is not possible to arrange a loan for him. Now, my lords, thereafter, what I do is, my lords, I refund this sum of, your lordships will first kindly see payment made to us by Annexure 3.
These are the matters to be decided in the trial, not here now.
Whether it's a civil transaction or a criminal transaction, right at the helm of the affairs, I mean, right at the starting of the proceedings, that has to be adjudicated first. My lords, if your lordship kindly sees page 31, that is Annexure 3. My lords, your lordships may kindly see on from the bottom, he has paid me 3 lakhs. From bottom 1, 2, 3, fifth transaction from the bottom on 6/12/2018, he has paid me 3 lakhs. Then, my lords, the page 32, the first transaction, again he has paid me 4 lakhs. So 7 lakhs in total he has paid, my lords. Then he claims he has paid 5 lakh by cash, of which he has no evidence. Anyway, that's a separate issue. Now, your lordships may kindly see Annexure 4. Page 33.
Transaction number 23.
Transaction number 23, I have refunded 5 lakhs to him. This is an admitted position. He discloses it in his complaint petition itself. Thereafter, my lords, page 34 and 35, 35 and 36, I'm sorry, my lords. I paid 1 lakh in cash to him, my lords. So now, my lords, he says that this amount.
Is there a possibility of settlement?
These are matters to be decided.
No. It's only how much do you have to, according to you have to get how many more, 4 lakhs or 5 lakhs?
No, my lord. 12 lakhs and 40,000 we have given. CIBIL score, they have assured me that CIBIL score is not up to mark, my lord.
No. How much money, according to you, how much does he still have to pay you?
12 lakhs, 40,000.
12 lakhs?
Yes.
How?
40,000, my lord.
How much money have you totally paid him?
I have given, my lord. I have money paid total amount, my lord.
You file a counter affidavit, sir. You file a counter affidavit. All right. Let's just see what the facts are. Notice is already, you see, Mr. Dardendra Nayak, senior counsel appearing for opposite party number 2, states that he'll file a reply to the present petition to bring on record what, according to opposite party number 2, is still owing to him.
You lordship may direct them to return my amount, my lord, the admitted amount they may return.
You state an amount, then we can send you to mediation. No. You can't simply say 12 lakhs, sir. There has to be some basis.
My lord, they have, this is their petition, my lord. My amount they have stated, my lord. It is, my lord.
See, he has repaid you, he says 5 lakhs.
No, he has repaid.
You reply to that. He's given you bank statements. You reply to that, so there's no problem.
But
we're not deciding it finally now.
But in a complaint case, during trial, if something is available for them, that can be utilized as a defense document.
We can narrow down the dispute.
That has to be proved.
Ultimately, if you settle the matter, if you agree, even your client does not want to be litigating for the next 10 years.
So next week, your lords may call it next week, my lord.
All right, you file a reply. You file a reply.
Obtain instruction, my lord, that my client is.
Whatever, sir. You file a reply. The rejoinder will be filed for the next date. There is no interim order here.
No.
There is no interim order, sir.
No, my lord.
All right. List before the roster bench on 18 July. 18 July.
85. May I please, your lordships. Lord, at the instance of opposite party number 2, Lord, one complaint petition was filed by OP number 2 against me, against the petitioner. That was dismissed under invoking under section 203 of CRPC. My lord, your lordship will find at page 33, the ordering portion. first paragraph, my lord, last line.
All right.
Accordingly, the case is dismissed as per section 203 of CRPC.
Right.
And a revision was filed by the opposite party number 2 before the Crown and Session Judge Puri under Annexure 3. But a notice, the direction was given for issuance of notice, but requisites was not filed by the opposite party number 2. But the revision was, my lord, decided and it is allowed, even without giving opportunity of hearing to the present petitioner, which is mandated as per section 401 clause 2 of CRPC, read with 399 of clause 2 of CRPC.
So where is
Opportunity
Mr.
of hearing
Banda?
has to be-
Let it go back, sir. All right. It is not in dispute that the impugned order dated 12th April 2021 was passed by the learned second additional session Judge Puri in criminal division 1-17 of 2021-2020 without notice to the present petitioner. On that short ground, the said order is hereby set aside. The aforementioned criminal revision number 1-17 of 2021-2022 is revived, is restored to the file of the learned second additional session Judge Puri, where it will be listed for hearing on 10th July 2023, on which date both parties will appear. The learned the said court is directed to proceed with the hearing of the revision petition and dispose it of as expeditious as possible and preferably within a period of 3 months thereafter. Deeply the petition, sir.
Item 86.
This is on behalf of Mr. Patnaik, who is not present. His father's death anniversary today.
All right.
Requested for time.
All right. Counsel for the
Petitioner.
Mr. Panda.
Patnaik.
Patnaik. But whose name is not there?
Item 86.
Viplav Bahali and his associates Kalinga Patnaik.
86 Bahali is a
Bahali.
Acha. It is stated the counsel of the petitioner is in some personal difficulty. List on 19 July.
Okay.
Item 87.
None appears dismissed.
88.
I have got the, I will file a reply, not agenda. I have got the civil court documents before Lordship, but not legible, I will file.
What's the matter about, sir?
Matter about 143A, your Lordship may let down the law, whether a 143A can be passed in a routine manner. Here, the harassment is caused by the accused, caused to the accused Miller. On basis of a registered sale deed, he has paid, he has received the amount and the title is with the complainant. Now he is making false allegation and this case has been mentioned.
You are for whom?
I am for the accused Miller.
Petitioner?
Yes, Miller. I am for the petitioner.
What do you say?
The Lordship may kindly see the impugned order, page 45.
I have got the civil court judgment. Civil court judgment, the restraint order, the very same complainant has filed a civil suit and restraint order has been passed in her favor in view of the land he has purchased from me. Now he is claiming 15 lakhs, whereas he has been registered deed has been made and 5 lakhs has been received. And I'll file these documents on affidavit.
Counsel for the petitioner seeks time to place and record certain additional documents which according to him are relevant to the present case. It's permitted to do so within 4 weeks with an advance copy to counsel for the opposite party number. Opposite party, yeah.
Mine.
Who's permitted to respond to the said affidavit before the next date. This before the roster bench on 28th August.
Much obvious.
89. 89.
Notice has already been issued in the complaint petition. I don't know anybody has appeared or not. It's arising out of a civil dispute. And I made submission which I am making by that. But at the notice, the complaint petition under annexure 1 and notice which I have received under page 19 manner, that differs manner. The same complaint petition, same number, but two different complaint petitions have been, one, the copy which I got from the court, the other, the notice which I have received. That shows by the qualified intention of the complainant only to harass by the present petitioners. Family members arising out of a civil dispute. 107 proceedings are pending between the parties. And they come nowadays, it's a practice to settle everything with a complaint case so that to bargain them to come to terms. Notice has been issued and
nobody is appearing for opposite party number 2.
I think nobody.
What do you say?
But after holding 202 inquiry, my lord, the magistrate has
Say,
taken cognizance.
complaint case,
When the
in fact,
complaint
balance the
has
state
been
has got
taken, my
nothing
lord,
to say.
it
We
is
have made
open for
state a
the
party,
petitioner to,
but it's arising out of
file
the complaint.
appropriate application at appropriate stage. my
What
lord.
is this?
Now the my lord cognizance has been taken after holding.
It's a
202
complaint case,
inquiry.
but it's not in pain, has got nothing to say.
Your lordship may kindly
Let the
page-
complainant, my lord, let the complainant
page
appear,
60.
my lord. Let her give you a chance, my lord, because notice has been issued.
I know, but for several dates now, the complainant is not appearing.
My lord, perhaps he has taken it granted that I have relied upon my lord 92 Supreme Court 604, where the prosecution has been maliciously initiated for taking vengeance.
But the whole thing is that she is actually apprehending threat to her life. Can you do one thing? Because of the nature of the allegation, why doesn't the IAC give a report?
Yes.
It's the nature of the complainant,
yes.
who is a lady, reveals that she's apprehending threat to her life at the hands of the petitioners. This could be one reason why,
It can be,
despite service of notice upon her, she has not been appearing on several dates.
it can be ascertained better way.
Yeah.
my lord.
The IAC of the concerned police station is requested to meet her and ascertain what the factual position is and make a report to this court and file a report before this court
And also can verify the correctness of this complaint petition. When it be ward one.
All right. Correct. That's what I've said. List on 17th August, interim order to continue. All right.
Item 90.
None appears dismissed.
Item 91.
Letter 91.
I'm looking for the opposite party, your lordship. In this matter, what has happened? A school girl, is a minor girl has been.
Let me place my lord. But it's a case where the matter relating to a dispute relating to the marriage, the petition number 3 married to the victim. Thereafter, that some litigation arises, and she now is matter before one of the cases before the judge family court. So what I thereafter he lost the criminal case. Now we are trying to settle the matter. Lordship will give you opportunity. Then the matter will be settled between both the parties. And because she is now denying that there is no such marriage. So that is why she has preferred
Where's the question of settling that, sir? Where's the question of settling?
Pardon?
My lord,
There's no question of settling.
Settlement, because it's a marriage. It's a apparent marriage. Marriage was settled between the party. Marriage
utilizing it as a marriage
document.
Then force her to come to her.
Both married, as per the caste, they married. Thereafter, she refused. Now she has preferred an appeal.
In my
case,
so your lord.
Before the judge family court, she has preferred an appeal CP case number 13 of 2019, which is now subjudiced. So now she is claiming that such marriage is not correct. So that is why that is subjudiced before the court. That is to be adjudicated whether the status of the marriage under section. So that dispute is to be settled, my lord. And what I got instruction, yesterday, that they are going to settle the dispute between.
If you settle, that's fine.
Oh yes, because several litigations
Nobody is coming in way of that if it is possible to be settled, but not at this stage.
At this stage, because it's a
He is disputing all that.
Disputing that disputing is before the judge family court, that is to be adjudicated.
It's all.
And that is to be adjudicated.
It's all right, sir. Not interfere.
That is the only, because it's your law. If your lordship will give them an opportunity, then
No,
it can be.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. All right.
Item 92.
Interim order granted.
Yeah. Interim order vacated. Right.
Item 92.
I'm appealing to the opposite.
All right. None appeals for the petitioner. Dismissed or not prosecution.
Item 93.
But 93, the matter arising out of a criminal complaint under annexure 1, where the complainant, with the opposite part number 2, he while executing a cell deed, he lodged an FIR. FIR was lodged by the official for
Perhaps when arrestment has not been instructed, he has challenged the proceedings. FIR has been, charge sheet has been submitted.
Oh. Permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item 94.
None appears dismissed.
Item 95.
Same order.
96.
95, you are for the respondent. Opposite party, just put his name. All right.
96.
I am for the opposite party.
All right, non-appeasable petitioner, dismissal not for solution.
Item 97.
Matter has been compromised between us, my lord, is appearing for OP2, that flag B is the affidavit.
The lordship, without taking consent,
Yes.
initially I was appointed for the opposite party number 2, but without taking consent, now the
Let the OP number 2 may appear in person.
Dispute between lawyers now.
Let the OP number 2 appear in person.
Although there's an affidavit of opposite party number 2 stating that the issues have been settled, it appears that there are the earlier counsel appearing on her behalf was not informed and has no objections not taken. That view of the matter, the court directs that opposite party number 2 should either take a proper no objection from the previous counsel or should appear in person before the court on the next date. List before the roster bench on 11 July. Right.
Pardon, my lord. Item 41 that was transferred to JMFC Pulsora instead of Kodola, my lord. 41, your lordship caused the.
All right, all right.
Obliged.
My lord, may I please the
And
lordship.
for opposite party number 2, my lord.
My lord, here is the case, my lord. The present affair arising out of a matrimonial dispute. The marriage between the parties in the year of 2015. In the year of 2018, the present petition number 1 is the only son. Went to the hospital, Apple Hospital, for the treatment of his my lord, parents, my lord. 2 and 3. Petition number 2 and 3 is the parents of the petition number 1. And there was a dispute, my lord, there was a hard talking between the parties, the complainant and the present petitioners, all the fun. And on slipping of bad language, my lord, the magistrate took cognizance, my lord, 498, 506 and other offences. That is the ground, my lord.
Sorry, no settlement, nothing.
No.
All
No,
right.
lordship.
Permitting the petition.
My lord, may I pray? My lord, one petition, my lord, 2 applications filed before the family court. The present
taken
petition
the-
of my lord, section 13, and the wife instituted is section 9. And your lordship kindly turn to 1 second, my lord, that order. Turn to page 27. What she has given a statement before she has no allegation against her husband.
And it is to stay with him. Correct.
She has no allegations. She has nothing, my lord, only grievance, only her grievance not to stay with your parents. Only grievance. And how many cases
No. They are missing out a very crucial word in that sentence. They have tortured her. She used the word tortured.
But thereafter, my lord, the word says, my lord, she has no allegation against her husband.
That's all right. Permitting
My
the
lord,
petition.
at the time of charge, my lord.
My lord,
At the
serious
time of
allegations
charge.
are there.
Anyway, he's himself saying, okay, permitting the petitioner to raise all pleas.
At the time of
appropriate-
charge.
Yeah.
And second one is the CRLMC 13 of 2022. Here is the case, my lord. The same transaction, second affair registered, my lord. That is my stand, my lord. First affair, my lord, last
There
2018.
are serious allegation against the petitioner, my lord. The petitioners
No,
are
no,
the
why
husband.
2 FIRs? That's the only question. Why 2 FIRs for the same incident?
Same
He has
transaction,
taken
my lord.
the interim protection and in very serious allegation
No,
498 my
whatever
lord.
serious, why 2 FIRs? Why a second FIR is to be registered? That's the question he's asking.
Yes, 13 is the, my lord, written in the vernacular by the police.
What is the earlier FIR number?
Earlier affair number is the, my lord, the first one. The first one where your lordship CRLMC 19 of 2022. That has been registered in the year of 2018. I have annexed here also.
Let's see the FIR here.
My lord, I am reading the page 13, my lord. On 13/6/2020, at about 1:36 AM, the complainant, the Saswata Patnaik, wife of so and so, and PS and presented a written report alleging therein.
Second FIR, just see.
This is the second FIR, my lord.
No, second FIR, come, you read it, para 12, I mean, column 12, page 13. This is subsequent cause of action, sir.
The page 19 is
Not
the
the same, it's not the same cause of action. All right. Second one also same order, permitting the petition to resolve this. All right.
Item
At the
99.
time of charge, my lord.
Whatever states, it's up to you to decide. All right.
99. sir.
Item 99, my associate, Mr. Mishra, Ashish Mishra is ill, my lord.
Well, I am appearing for the trial was stayed, my lord. 498-304B, 306, and marriage be 1 year and half with the deceased, my lord. The deceased was died, my lord.
Let it come up next
Trial or stays and challenging the cognizance, my lord. 498-304B, 306, and 4 DP Act, my lord.
Why don't we vacate the interim order, sir?
My lord, I just pray for next week. Because my lord, he actually is suffering from fever. So I don't have the file with me. Next week, any date, your lordship takes it. I'll ask you.
Counsel, the petitioner stated to be unwell. List on 16th May. Interim order to continue.
Deeply obliged.
Item 100.
I raise all the points before the court below.
All right.
Only
Permitting
prayer
the
minutes.
petitioner to resolve, please.
Only prayer minutes. The lordship may can direct the lower court to expedite the procedure. Only one. Only
All
one.
right, including requesting the lower court to expedite the proceedings.
Gratefully.
Okay.
I beg pardon, my lord. I have one CRLMC. In this matter, my lord, matter has been compromised between the parties. So, my lord, I pray only, my lord, on next week on any date, kindly be listed.
Just take it. 1 o'clock. 2 more.
was granted, my lord. Here, my lord, compulsory appointment. You lost my restaurant, here it is married, my lord. Compulsory appointment. Father, brother died, my lord. Father while in service and is in workplace, my lord, is suffered, my lord.
2008 matter, sir.
Eight man only compulsory appointment. Compulsory
1389 days.
How much? Sorry?
1389 days.
My lord, you lost me for a poor man boy, my lord, you lost me condone that deal. For in other cases, I will not prefer.
Till date, he is sitting idle.
Yes, my lord. Two brothers, young brothers, my lord, they father mother died, my lord.
Then
They became orphan, my lord.
then he is unfit to be in the service.
No, he was, no, my father died when he was in.
Let him make endeavor for any other.
Your my restaurant on merit, you lost me here. Restaurant on merit.
Delay has to be reasonable delay, sir. Not like this.
Unreasonable. He could not know, my lord. Advocate did not inform me.
No. Up to a point, it's all acceptable.
Petitioner will suffer for that.
That's all right.
That is
1389 days delay is not satisfactorily explained. Consequently, the delay is not condoned.
well, liberty may be granted to file after my lord.
No. As it is a 2008 petition.
Compulsory appointment, my lord.
We're not inclined, sir. Sorry. Yes.
Item 9.
Along with me, Mr. BK Padi, please.
All right.
Yes.
Due to internet connection, poor internet connection, I cannot appear with your lordship on 17th February.
No. This is for 17th February. Which date?
17th February, none appear for the appellant.
2023.
No. IA was dismissed.
The CMBP, IA.
You was looking for restoration of the IA.
Yes.
What is the IA about? That was for recall of that earlier order. Oh.
Yes. IA is for the
That is again recall of.
Recall of recall. What is it? Because it's beyond
monetary limit.
Monetary limit.
Yes.
Okay. All right.
Okay.
For the reasons stated therein, the application is allowed. As a result, IA is allowed. And then this ITA is restored to the file of the roster bench. Now that ITA is listed before the roster bench on 2nd August. All right.
1 minute.
There's a special notice matter.
Yes.
Matter on special CRLA 552 of 2016.
Yeah, please. My lord, petitioner has filed an interim bail application, my lord. The wife is pregnant, my lord. And doctor has
You've checked up?
Please, I'm giving the instruction along with the MCP card, Mother and Child Protection card. That is annexed.
It's correct. All right. Mr. Katkia, learned counsel, standing counsel for the state, produces before the court a report of dated 10th May 2023 of the IIC Sorada PS, confirming that the wife of the applicant is pregnant and the probable date of delivery is 15 June 2023. All right. In that view of the matter, the applicant is directed to be released on interim bail for a period of 4 weeks from the date of his release. That is, when do you want to be released? The longer it is, the better for you. The expected date of delivery is 15 June.
15/6.
From 1st June, you go for 4 weeks, sir. From 1st June, 1st June 2023 onwards, for a period of 4 weeks, subject to his surrendering immediately on the expiry of the set period. Certificate of surrender be placed in record. The application is disposed of. It will be subject to the terms set by the trial court. All right.
Yes.
All right. Right, sir. Right, sir. Namaste.
Present, Mr. Item number 1.
In this matter, can be done to this. Para 3 of the petition mentioned. Restoration application.
You have this.
Yes.
Justice Patnaik, have they given you a copy of the order, 15 March?
No, I do not have a copy of the order.
All right. There was another writ petition 798. So, along with this, in which we've passed an order.
Yes, madam.
So, he wants an identical order in that. But who's appearing for the other side? You are there. Same order can be passed. All right. For the reason stated, the amendment is allowed. Then this is restored to file in 798, in the 796, you say this dates have to change, sir. The dates will have to be changed. Do you have a certified copy in this?
Yes, madam.
You have a, no. The Tahsildar's order.
Yes, I have.
In that case, the Tahsildar's order, you did not have a certified copy. In this case, do you have?
I think I have. They are not issuing any certificate. That's the
All right, same thing. Okay. One of the grievances made in the present petition is that the petitioner has been unable to get a certified copy of the order dated. Same order.
Here, my lord, SRF number 17/2006.
Order dated same thing.
Punch.
Tahsildar's order.
Punch. Indeed. Yes, the Tahsildar is same in all cases. Because 4 cases.
27 January.
Yes.
All right. Order dated 27 January. 7 of the Tahsildar Soro granting the ROR. Paragraph. In the reply filed by the opposite parties, it is stated that the certified copy could not be prepared for want of court fee. Full stop. In the circumstances, it is directed that the petitioner will deposit the sum of rupees 250 towards court fee with the Tahsildar Soro on or before 1st June 2023. Certified copy of the order dated 27 January 2007 in SRF case number 17/2006 will be supplied to the petitioner on or before 15th June 2023, in which event it will be open to the petitioner thereafter to challenge the said order of the Tahsildar in accordance with law, filing an appeal on or before 15 July 2023, along with an application for continuation of delay, citing the pendency of the present petition as the reason for the delay. Full stop. It is clarified that the court has not expressed any opinion on merits. Full stop. A certified copy of this order be produced before the OP number 6 within 1 week from today for compliance. No, produced on 1st June 2026, 23 for compliance.
By 1st June, not within the 6 weeks, by 1st June.
1st June they produce the order.
The writ petition is disposed of.
Item 2.
I may pardon for the same order. Other 2 applications are also present.
You have to file, yes, unless you file, it can't come.
Item 2, my lords, in this case, I am appearing for the opposite party since 2013, my lords. So my name did not found place in the order sheet, my lords. So I pay my name. That matter has been disposed on 8/8/2022, but my name is not reflected.
All right. The name of the applicant
for opposite party, my lords.
For opposite party number?
Only sole opposite party, my lords.
All right, be reflected in the order dated
8/8/2022, my lords.
8/8/2022. Right. All right.
Item number 3.
My lord, I am appearing for OP party number 4, my lord, and I have filed this IF for recalling of order dated 6/7/2022. And kindly see the order 6/7/2022 for a moment, my lord. May I please?
Yes.
The petitioner is before the NCLT. Consequently, this petition cannot continue, and the parties are free to approach the NCLT for appropriate reliefs. The writ petition is disposed of. My humble submission before your lordship. My lord, NCLT has no jurisdiction to decide the issue which was referred by the state government to Industrial Dispute Tribunal, my lord. Issue was that whether the termination of service of
No, how are you? You're not for the petitioner.
No, I am for office party number 4, my lord. Workmen.
Why would the workmen? How can they continue? They would have claims against the company, right?
No, so some issue was to be decided.
What was the issue to be
The
decided?
issue that whether the termination of service of
So clearly, so that will involve the company having to either take you back or pay you the compensation lieu of reinstatement.
But my lord, there was no compensation as such was.
No, the issue involves that, sir.
But NCLT, my humble submission is NCLT has no jurisdiction to enter.
No, you're wrong, sir. You're mistaken on that.
There is no provision to how shall I approach?
You will say that this is your claim against the company.
But my humble submission is the industrial tribunal is the
There's
appropriate
no,
forum.
sir, you have to read the IBC. No court anywhere can proceed with any matter once the company is before the NCLT. All right. There's no merit in this application, Mr. Sach. All right.
Item number 4. Item 4, my lords, there has been a delay of 58 days. I have filed an application for condonation of the delay. Review has been sought on behalf of the state for the reason that the decision relied upon by your lordships while passing the judgment also covers this case, in the sense the same intermediary who had been in possession of those lands, he had alienated those properties which are claiming to be Nizdakhali lands, and those were settled in their favor in these cases, which were subsequently set aside by the member under the provision provided for under the Odisha Estates Abolition Act. That order of the member Board of Revenue was impugned before your lordship, and your lordship referred to one of the judgments of the Honorable Supreme Court. The copies, the hard copies I have got. There the Honorable Supreme Court, referring to the nature of the land, had said that it could not have been settled, so what the member had done is correct. So that was upheld by the Honorable Supreme Court, and your lordship referred to that judgment. But the land covered in this case, which your lordships have already decided, and the judgment wherein is sought to be reviewed with an apologetic tone that it should have been brought to your lordship's notice at the relevant time. At the same time, your lordship will kindly find that the same nature of land is involved in this case, which was held to be Anavadi land of the intermediary and could not have been a cultivable land, so it could not have been settled, and the member's order was justified. So that only to the limited extent that the judgment which your lordships have referred to of the Honorable Supreme Court covering the same nature of the land being involved in this case, your lordship may reappreciate. That is the.
I don't think this is a ground for review, sir.
Pardon me?
This is not a ground for review, sir. You may challenge it in appeal. That's a different.
No, review is only on to the limited extent that had these things been brought to your lordship's notice.
That is, it is all within your control. So it's not a newly discovered thing. See, 47, you know that it's a very limited review, sir. Limited grounds.
That is of course there, but this, if your lordship appreciates, then the
not a ground for review. All we are saying is not a ground for review. No grounds made out for review.
That is for your lordship's consideration.
Yes.
I cannot.
Correct. All right. No grounds made out for review. Review petitions. Right.
Well,
Namaskar, sir. Pranam.
Item number 1.
Correction be carried out.
Yes.
As pointed out. All right.
Sir.
Right. This is Raman.
Pranam, sir.
Pranam, sir. Pranam.
Orders item number 1.
Excuse me. Wait, please, my lords. The short issue is that, my lords, we have prayed for correction, my lords. It appears to be a typo.
Oh, I see.
Look, my lords, your lordship has said 25F. It should be 25FF.
F. Okay.
No.
All right. The correction be carried out as prayed for. Wherever section 25F appears, the reference should be to section 25FF.
Yeah.
All right.
Item 2.
Same. No. Acha. I thought you were not. You are. He's for the opposite side. I thought.
No, I am for the.
Oh no. When he was standing next to him, I thought.
We were sharing one mic, so
You can come here, sir. You come.
Application.
Yes,
You are disposal of
let me.
Right.
under section 25A.
Yes.
25F, the amount has already been paid.
Paid. Oh.
Yes. Now they
No,
want to
sir.
make it 25F.
I'll explain to you, Lordship.
No, not that way.
I'll not argue also.
All right. Tell us.
Well, Lordship, order dated 11/4/2023.
Right.
This is an application filed by opposite parties 4 to 18 for modification of the order dated 16 January 2023. Mr. S.P. Mishra, learned senior counsel appearing for the petitioners, handed a list of 56 workmen who, according to him, have been paid the compensation amount in terms of the order of this court. On instructions, he states that there's repetition of the name of Samsundar Raut, both at serial number 43 and 52 in the said list. However, he states that said person and all others in the list have been paid compensation by way of the checks that have been dispatched to each of them individually by registered post 7 April 2023. Well, checks have come, but we have not encashed them. The reason is, ballots, we are pressing this application 25FF. Mr. Niranjan Singh, learned counsel appearing for the applicant opposite parties, makes two submissions. One, according to him, the compensation should be paid in terms of Section 25FF of the Industrial Disputes Act 947 and not Section 25F, as has been directed by this court in its order dated 16 January 2023. Secondly, he states that two more workmen, that is Nadia Sethi and son of Bonabihari Sethi, employee card so-and-so, and Mahendra Kumar Das, are not found in the list handed over today in the court, and their cases are identical to the cases of those who have been paid. On both the above submissions, Mr. Mishra, counsel for the petitioner, states that he will have the records verified and revert back on the next date. The documents in regard to the aforementioned two persons be handed over.
Actually, we have to hear him, therefore.
No.
16 January, the 16 January
The
order.
genesis of this, I'll just praying for my learned seniors, permission minutes. The genesis of this order is your lordship's order dated 30/3/2022. This was why your lordship passed that order.
Right.
Mallet. Lordship may kindly turn to my lord's paragraph
33.
Paragraph 22, my lord, order number 22. Order dated 33/2022, order number 22 also. On 12th August 2010, the following order was passed by this court in both these writ petitions, one of which is by the management, being writ petition number 9842 of 2009, the other by the workmen, being writ petition number 16443 of 2009, challenging the same impugned order award dated 18th May 2009, passed by the Industrial Tribunal Bhubaneswar in ID case number 4 of 2005. Heard learned counsel for the petitioners. Both the petitions, having been arisen from one order, they are heard together and the following common order is passed thereon.
What is the difference in if it's 25FF, you have to pay something
Minus
more?
25FF means automatic.
Here, the termination of their non-acceptance of the employees prior to. This is not after the merger.
25
prior to. Therefore, 25F is applicable. So you are saying rightly indicated 25F.
No, the context is different, my lords. Context is 25FF. I'll take for you lots, my lords. For a second one, lordship, bear with me. 25FF, compensation to workmen in case of transfer of the undertakings, where the ownership or management of an undertaking is transferred, whether by agreement or by operation of law, from the employer in relation to that undertaking to a new employer. Every workman who has been in continuous service of not less than 1 year in that undertaking immediately before such transfer shall be entitled to notice and compensation in accordance with the provisions of section 25F if the
conferring for 1 year.
if the workman has been retrenched, this is the key one, the crux. If the workman has been retrenched, then only minus 25F will apply, provided that nothing in this section, minus emphasis applied, shall apply to a workman in any case where there has been change of employers by reason of the transfer if the service of the workman has not been interrupted by such transfer. The terms and conditions of the service applicable to the workman after such transfer are not in any way less favorable to the workman than those applicable to him immediately before the transfer. And the new employer is under.
We've heard you actually when the
Malak,
order was
in-
passed on 16 January.
Yes.
You were heard at length, sir.
Malak, in
After hearing-
context,
Now you're
in
trying to say in this application violation of natural justice as if you've not
Malak, in
heard.
context,
What is all
in
this?
context, with great respect, Malak, in context, your lordship's order is that only.
Yes.
That is what I
Sir, all this should have been pointed out on 16 January.
Malak, that is all, that your lordship's order is there. Your lordship will kindly, my lordship.
You've suddenly woken up after
No.
the checks were issued, sir.
My lordship,
In fact, all these particular
paragraph
matters,
2, my
you've been
paragraph.
hearing at length. You've been
Lordship,
hearing all
kindly,
of
this
it
is a
length.
question of livelihood of this workman. Paragraph 2, my lordship, your lordship's order, had it not been
Sir,
there in your lordship's order, had it not been there in your lordship's order, my lord, I would not insist. Paragraph 2, pursuant to the above order of the tribunal, the tribunal again, it was remanded back because it never decided the issue of these 151 workmen who produced documents that they were in employment with the mallards Oswald at the time of transfer. Pursuant to the above order, the tribunal again heard the parties and passed another award on 16 December 2010. The operative portion which reads as under.
Sir, look at 16.
That was not accepted.
Look at 16 January order, sir.
Mallards.
Look at the 16 January.
Yes.
Your lordship has quoted this order, extracted. In view of the discussions made above, this is the tribunal. In view of the discussions made above, it is held that all those disputed workmen whose retrenchment is found to be illegal are deemed to be employees of the undertaking as on 39/2005. There is no dispute.
Mr. Palit, you were present actually.
No, I was not present. When
16
this order-
January? Of course you were present on 16 January. What are you saying?
No.
16 January, your appearance is noted.
It was hard, council. was
Yes, yes, in your presence it was passed.
16 January.
Yes.
No, 16 January. I am
Yes,
reading
yes.
the order. I am reading the order 33.
No, this is not an
22.
afterthought. In your presence, the 16 January order was passed. Yes.
No, your lordship's order, it was passed.
There's a question of recall of that order. I'm not able to understand.
Your lordship passed the order.
Interim application, interim
Malak,
application,
33.
again reheard.
Malak, 33,
It is not review.
Malak,
It is not review.
You can't review it, sir.
Somebody. Malak, the issue concerned the expression disputant workmen without categorically answering the issue framed the tribunal addressed by this court whether IFCO is liable to give employment to all the 151 workmen. The tribunal seems to have indirectly restricted the relief to only 8 workmen by describing them as disputant workmen. This was the
This can't
lordship.
be done like a recall application, Mr. Palit. Sorry.
Malak, I am only modifying. I am not recalling. I am only applying for a modification.
No, this is not neither modification nor recall.
That is the reason.
Correction only.
It goes to the rule.
No, that is the reason your lordship said, kindly, my lord, lordship may not misunderstand me, kindly, my lord, the lordship's order. Not a single line, my lord, from my own mind, my lord, lordship's order, Mr. Singh, appearance person, makes a grievance, this was the basis, makes a grievance that their clients are ready with additional evidence to be adduced as proof of their employment with Oswald before it was taken over by IFCO. This is the key and crux. Their grievance is that no opportunity was given by the tribunal to place the said evidence before it. And then the next paragraph, with a view to obviating a further remand which will delay the matter, the court considers it appropriate to direct as under. The workmen who wish to be reinstated. Why would your lordship direct a reinstatement, observe a reinstatement if it was not in terms of 25 FF? Your lordship being conscious of 25 FF, and this direction was passed. Who wish to be reinstated in service and who have not crossed the age of superannuation shall present themselves before the general manager at Paradip between 18th and 22nd with all relevant documents. So your lordship managed to obviate that difficulty that why these employees will be sent on a leather hunt again to the tribunal. Your lordship wanted to cut the long story short. Since the document, your lordship wanted to cut the long story short and say that you produce the document, they'll be taken into employment. The general manager will arrange to have those documents checked and verified. It will be open to the IFCO if the documents are found to be in order to either to offer the workman whose identity is established reinstatement or compensation in lieu of reinstatement. This is without prejudice to the rights and contentions of both the workmen as well as IFCO. It is expected that at least some of the issues might get settled in the process. So, my main right is to get more money in terms of 25 AFF. And I have been running from pillar to post for the last 15 years. And only 15,000 rupees at this day and this age. By retrenchment. How can the retrenchment apply as on date? This is something that was automatic by virtue of the statutory by the dint of the statutory amendment, 25 AFF. And I should have been automatically continued because I was presenting the document which the tribunal could not examine. Your lordship said, all right, they will examine it, the general manager will examine it. It's a question of livelihood, Article 21 directly, and statute gives me that right. That is the reason and that is the spirit of your lordship's order. And now they want to play a subterfuge on the statutory right by giving a simple compensation of 25F. Where do we go from here, my lords? Now, your lordship's one observation is going to ruin our chances of getting any other relief.
What do you want? You want this whole order to be recalled?
No, we just want this modification.
You'll return all the checks now?
My lords, checks will be returned.
You'll return and you want the whole matter to be heard again?
My lords.
All right. Mr. Subir Palit, Learned Counsel, appealing for the applicant, today states that the applicant workmen are not satisfied with compensation being paid under Section 25F of the Industrial Disputes Act 1947, and they're insisting that they should be paid in terms of Section 25FF of the Act. Full stop. This submission ought to have been made when the order was passed on 16 January 2023. Nevertheless, since Mr. Palit insists that the workmen are unsatisfied with the order and is offering to return all the checks back to the management since they have not been encashed, the said order dated 16 January 2023 is hereby recalled. Full stop. The writ petition now be restored to file and be listed before the roster bench for hearing on 21st August 2023.
Great.
All right.
They have many of them have encashed the amount. They should be directed to.
None of the petitioners have encashed. Yes. None of the petitioners for whom an affidavit will be filed. That's the instruction. An affidavit will be filed.
Clarify. They have encashed. That's for my instruction.
Okay. If in the event that any of the applicants, I hope this is by all the persons who have this IA is by all persons who have the respondents or only by some?
No, he is not appearing for all.
4 to 18.
How many checks were issued, sir?
Yes,
56.
One check returned back because of one Kartika died. In the meantime, that check.
They cannot now recall the entire order.
Other checks were issued by the all workmen, 55 workmen.
Sir, 55 persons.
Yes.
Are all before this court?
No, that's the interesting thing.
Yes, my lord.
Yes.
No.
They are before.
Yes, my lord.
Sir, all 55, you have the 55 checks with you.
Yes, my lord.
Show this 55 checks. Just return it here only.
Sir, he is appealing for few persons that have come.
You bring those 55 checks, we'll have it next Friday. You bring the 55 checks, you return it to them, then we'll pass this order.
Yes, my lord.
Or list, just no orders, just say list next Friday.
I may not be misunderstood, my lord.
I don't know about that.
No, you are appealing for 4 persons.
Yes.
Second item, my lord. 6905 IA filed by the opposite party to union to recall the order that Tiris 33.
Sir, they did not appear for 9 days when the matter was taken up hearing. Now 2 applications filed to recall.
My lord, I should not count up my senior, My lord, your lordship passed order
And this also
33,
call this next.
30th March 22, my lord. They didn't submit the report. Their report submitted on 16 January.
Workmen got the
Didn't
benefit.
serve a copy on us, and the same day the order, the fortunate to get the order, my lord.
Item number 3.
My lord, both the my item, my lord. 6905 IA and in the Soldier, that is 6987. my lord.
Same, next Friday.
Item 3.
My lord,
Same,
we
sir.
the-
2 and 3 are the same. We are
My
just
lord, my-
adjourning 3 also to Friday. Why are you again calling? He is appearing in 3.
I am, my lord. Yes, I am.
He is in IA 6987. This
Yes.
6987 is also adjourned to next Friday. All right.
Yes. Second case is.
Now please call item 4.
Item 4.
My lord, my name is missing, my lord.
All right. Please put his name.
Pradeep Kumar Das.
All right.
Item 2 and 1.
All right.
Lordship, by way of this order, I am seeking for extension of the date to file the reply.
Yes.
Your Lordship, by order dated 20th February, directed me to file reply on or before 1st May.
All
So
right.
that date has gone by. I seek for an extension of 30 days to file my reply.
All right. Time to file reply is extended by 30 days. Correspondingly, the time to dispose of the matter is extended accordingly.
Obliged.
The
Your Lordship.
application is allowed. All right.
Item number 5.
This is for correction of cost title.
All right. Be corrected as pointed out. All right.
Published.
Right, sir. Namaskar, sir.
Sir, pranam, sir.
Pranam.
For orders, item number 1.
My lord, in this case, it was dismissed on prosecution because one of our CGC could not appear. It's a delay of 13 days. So my lord may consider after 30 days, has filed 30 days.
What's the main matter about?
Lord, it is a proceeding under dismissal, and after dismissal, there is a state in that it was dismissal. He approached the honorable single judge. Against the order of the single judge, we will file the writ appeal matter. There is a declaration on that issue that today there is a contempt they have filed that issue listed before this honorable single judge, my lord. But facts remain that he has deposed himself that we have satisfied with all the documents has been served on. This statement is already recorded by us. It was not taken into consideration and order was passed. So it may be restored and finally it was hard.
Your Lordship, just a minute. Your Lordship.
Yes, tell me.
My lords, I am appearing for the employee here, Your Lordship.
Yes.
There has been a contempt case which has been pending, which was also fixed to today. And friend said before the court that they have already partly complied with the order. If they have partly complied with the order, where is the question of recalling this?
No, my lord, I am just, it is my lord, senior
Just
is.
a minute, let me finish. Let me finish. You have done enough. So
What and I have done? I don't know, nothing to do anything in this regard.
Order has been passed and in the court, Your Lordship, the order has been placed that they have partly complied with the order. I checked up with the employee, my client yourself, she says that nothing has been complied. And it is a false statement. And on that ground only, the matter has been adjourned to next week, Your Lordship. And now they say that it should be recalled. And as per my information, I don't know, Your Lordship, whether it is correct or not, but it is 250 days delay. Your
44 days, yes. 244 days delay was there.
44 days, Your Lordship. And where is the explanation, Your Lordship, may kindly see? And how it can be recalled, Your Lordship? Your Lordship sees
No, madam. After this, if my land is senior complete, then I will start. Yes.
Delays to 44 days.
No. Sir, according to me, my lord, just FAR non-appear dismissed. Thereafter, after 30 days, it will file after 14 days.
Item 1.
Yes, sir, 30 days. Yes. Item 1. Yes.
Yes. Item 1 writ appeal is.
The writ appeal probably was delayed.
Yes.
Yeah, writ appeal.
No, but that delay I think was.
My lord, what happened?
That is the matter to be discussed.
After dismissal of this non-appearance dismissed, they have preferred to file a contempt. In that contempt, there's an order of the honorable chief.
We are on the original writ appeal. Suppose we restore it also.
Yes.
In the
Consequence, I am explaining, my consequence, I am explaining. What I am just one.
No, I'm just pointing out to you.
My lord.
The original writ appeal,
my lord,
was delayed by 244 days.
Yes.
That delay was never condoned.
No.
But I'm explaining, I'm come to that point, just I'm coming what my senior has submitted about this partly compared with. After dismissal of the non-prosecution, they were dismissed. They have filed a contempt. In the meantime, contempt has been filed. In contempt, there is an order. If this order was not complied with, the IG will appear in person. So they asked advice. I told that yes, court has only single just passed such order. Partly were complied with, and it will left to the court. After outcome of the writ appeal, then whatever the final outcome is there, it will be confirmed.
Today we'll just now come to the delay in filing the writ appeal. Come to that.
Yes.
There's no explanation at all.
No explanation.
Absolutely no explanation.
Maybe this prior to that it was filed in 2016.
That's right. So that's the end of the matter.
My lord, but
so for the reason stated therein, the same APL is allowed. Writ appeal is restored to file. In this writ appeal, you see this writ appeal is directed against an order dated 5th May 2015, passed by the Learned Single Judge in OJC number 7854 of 1998, whereby the writ petition was allowed, and an order dated 17th March 1997 and 31st July 1997 in the disciplinary proceedings against the respondent was set aside. Paragraph. The writ appeal is delayed by 244 days. Full stop. Miss case number 121 of 2016 has been filed for condemnation of delay.
Yes.
Full stop. The only explanation offered in this application reads as under paras 2, 4 and 5. Yes. Take from that. In terms of the legal position explained by the Supreme Court of India in Postmaster General versus Living India Media Limited, and State of MP versus Berula, and a series of other judgments, the above decision is totally inadequate to explain the extraordinary delay of 244 days. Consequently, this case is dismissed. As a result, the writ appeal is dismissed. That's the end of the matter. All right.
Gratefully.
Number 2.
Yes.
Item 2.
Along with Mr. Pradhan, Amitabh Pradhan.
Yes.
May I please it before last? Now, in this case, the petitioner, which is a private honorary technical education institution, sought for the review of your lordship order, 2 orders, Miller, that was under Annexure 6, that was passed, that is the main order, that was passed on 20 October 2020, Miller, and the subsequent order also, Miller. In fact, Miller, in the first order, the petitioner before lordship in this review application is not agreed, Miller, because the cost, that is the amount here, Miller, the background of the case, your lordship may kindly appreciate, Miller. The OP number 1 is the student concerned, Miller. He had approached this honorable court through a writ application which was not entertained by the honorable single judge, and subsequently he preferred, Miller, writ appeal before this honorable court, and the case of the student before lordship is like this, Miller. His case was in the for the academic section 2013-14, Miller.
1 minute.
He got admission, Miller.
Whom are you appearing for?
Miller, I am appearing on behalf of the respondent number 2 and 3 institution, Miller.
GIET.
Miller. They were respondent number 2 and 3 before lordship in the writ appeal, Miller.
Right.
Miller, in the first order, your lordship has held that
the government will refund.
Miller.
Yes, the government will refund.
Yes, Lordship.
Yes, Miller.
First said government will refund. In the second order, we have said you will refund.
Yes,
First order, Miller, your lordship held that the student concerned is entitled to get a seat in respect of the TFW quota, tuition fees waiver schemes quota, Miller. Miller, here in this case, subsequently, Miller, this honorable court, taking into consideration of the IA, it has been filed by the state, Miller, modified the order and shifted the liability on the head of the present petitioner, Miller. Lordship may kindly appreciate, Miller, what are the undisputed case before lordship, Miller. The undisputed case is that, Miller, the petitioner had sought for take admission in respect of the TFW quota seat, Miller. And admittedly, the petitioner had opted before the JE. JE is the competent admission authorities. And under the state statute, Miller, it is within the domain of the JE, Miller, to take admission and to, through its counseling process, to assign the students to the various institution, including the present petition institution, Miller. Everything was done by the JE, and the TFW quota, it was introduced by the AICT, which is a supernumerary quota, Miller, and the as per the AICT, the competent authority of the state government is also competent to look into that TFW quota. The petitioner student before lordship with the appellant Miller, he had opted for two quota. One is on reserve quota in respect of the same college, another is TFW quota, Miller. So far TFW quota is concerned, Miller, he had opted his option before the JE through its counseling process, Miller. That was on merit, it was not accepted. We are no way concerned for that admission, Miller. Now the liabilities has been shifted on our head. Then your lordship may kindly appreciate the JE counter which was filed before lordship in the writ appeal, that is very relevant. They have raised all the relevant, some of the relevant issues for your lordship kind consideration, and that was ignored. Your lordship may kindly come to annexure 4, that is the JE counter, Miller. In the writ appeal, they have filed, Miller. In the writ application, they did not file any counter. Your lordship may kindly appreciate it at running page 81 of my brief, Miller. I am just reading out what the relevant points they have taken, Miller. 81, Miller. Miller, para 4, I am just reading out from para 4. The AICT has introduced tuition fees waiver TFW scheme, which is applicable to all approved technical institutions offering bachelor program, diploma, post diploma program, including lateral entry provision under said program. The seats up to 5% of the sanction intake as per the course is available for TFW scheme. These TFW seats are supernumerary in nature. The competent authority, that is important, Miller, the competent authority for admission to the seat under TFW scheme shall be same as per a regular admission. Then your lordship may kindly come to next para 7, Miller. They have extracted the provision of law which I have filed in annexure 1, that is the Act, Miller, and that is, I am just reading out. Subject to provision of this Act, admission of students in all private professional education institution, government institution and sponsored institution to all seats, Miller, including lateral entry seats, shall be made through JE conducted by the police body. Miller, here the JE has faulted, Miller. Then your lordship may kindly come to the student's own document, Miller. That is that page, Miller. I have annexed. That was before lordship, he had annexed it 53. Your lordship may kindly come to 53 page, Miller. That is the student's own document, Miller. The student's document, I'm just reading out. It was made by the student through his guardian father, Miller, on 12/4/2014, Miller. 12/4/2014, Miller. In fact, through JE, he has admitted in the college, Miller, for the academic session 2013. That is before 7 months, Miller. Particular date, Miller, documents were before lordship. That was on 19 July 2013, Miller. Here he has opted for changing to TLW, Miller, seat, Miller, on 12/4/2014. Then your lordship may kindly come to 86, page 86. That was immediately responded by the institution because the institution was helpless, Miller. 86, I'm just reading out. That is annexure 4. On 21/4/2014, that is the institution letter. That is the institution letter, Miller. On 12/4/2014, he sought for his admission against that vacant seat, and 21/4/2014, we refer this matter to the secretary, to the government department of ET and ET, that is the concerned government, Miller. Then your lordship may kindly come to very important point, Miller. That was also pleaded there in the JE, Miller. Your lordship may kindly appreciate the Parasbanath case, Miller. Your lordship may kindly appreciate that judgment, Miller. Parasbanath case, Miller, that is the cutoff date which has been fixed by the Honorable Supreme Court and said that any deviation is a contempt of the Supreme Court also. Your lordship may kindly, that is the authority to the authorities. That is page 406 of the that's the reported judgment. Miller 41, I am just reading out. The appropriate schedule thus would be as follows. And I'm just reading out, my lord. 1, 2, 3, 4 from the top of the schedule, that the bottom. Your lordship may kindly come to 1, 2, 4, just four column from the bottom of that table. The last date up to which students can be admitted against vacancies arising due to any reason. No student should be admitted in any institution after the last date under any quota, including tier 1 quota, that is 15 August, Miller. The admission process, it was over as per the Parasparnath guidelines and the Parasparnath schedule on 20 July, Miller, and the student council, he was sponsored to our institution through JE on 19 July and took the admission on the very same day. 20 July is the last date, and as per the Parasparnath case, Miller, any quota seats cannot be filled up or cannot be disturbed after 15 August, Miller. Then we had no role to play at all for the TFW quota, Miller. If he had opted on any seat he had got through the JE, Miller, then one seat remained vacant in our college. It could have been filled up by the college institution itself, Miller. The institution had no fault at all before the lordship, Miller. And that is the undisputed case. It is a case which needs to be reviewed for, Miller. Otherwise, Miller, the greater injustice will be caused to the institution, Miller. It is a private unaided institution, Miller.
All right. You're done, sir?
Miller, that's
all right. No grounds made out for review. The review petition is dismissed.
Item number 3.
May please, Your Lordship. I mean, busy, Your Lordship. In this case, Your Lordship, the read application has been dismissed for non-prosecution on 20/10/2022, Your Lordship. So, actually, I pray Your Lordship can restore the read application.
When is this application filed? When did you file?
Your Lordship.
File a certified copy, so no stamp reporting could be made, sir.
I will comply, Your Lordship. I will comply.
No, what's the delay? What is the delay in filing the application? Where is the explanation for the delay?
So I will file the limitation petition.
All right, you say the application is in defect. Defects be cured. This application will be listed only after all defects are cured. All right.
May I say one thing, Your Lordship? May I permit to place the regular bench, Your Lordship? Kindly permit me.
For what? The application is in defect, so you first cure the defect, then we'll hear you.
Yes, Your Lordship. I will remove the deep reply.